Good afternoon. Welcome to the Appellate Division First Department. My name is Justice Barbara Kapnick, and the session for virtual oral arguments for April 8th, 2021 is now open. I am going to call the calendar first, but I just want to make you aware that we have an extremely long oral argument calendar today. So I want to remind you that we have had your briefs and your record for some time now. We are fully familiar with your cases, and please just hone in on the really important points and be sure to answer our questions succinctly and as briefly as you can so we can get through the calendar before it gets dark this evening. So I am going to start at the beginning, just make sure everybody's here and that you know how much time you have been allotted. In a few cases, I'll make a few other comments. Okay, number one on the calendar is People versus Miguel Cortez. That case is submitted. Second, Mulgrew versus Board of Education. Appellant.
For the appellant, Christopher Lewis.
You have 5 minutes, and respondent, Board of Education.
Yes, Zach Shapiro for respondents.
Okay, and you also have 5 minutes. The next case is Al-Saud versus New York Presbyterian Hospital. Appellant Hospital.
Good afternoon, Your Honor. 5 minutes for appellant.
Okay, thank you, Mr. Ratner. And respondent.
Good afternoon, Your Honor. This is Hannah Miller from Hughes Hubbard for respondent.
Okay, and you also have 5 minutes.
Thank you.
Five Star Contracting versus Board of Trustees of FIT. The appellant FIT.
Good afternoon. This is Scott Matthews of Windells, Marks, Land and Mittendorf for the appellant.
Okay, you have 6 minutes and 2 for rebuttal. Respondent Five Star Contracting.
Good afternoon, Your Honor. This is Paul Vink for Five Star Contracting.
Okay, and you also have 6 minutes.
Thank you.
Kopelovich versus 200 Water, the appellant. Sir, you.
Apologizing into Chico for the appellant.
Okay, you have 5 minutes and 2 for rebuttal, and for the respondent.
Good afternoon, Your Honor. Stephanie McDougall of Dorff and Nelson for respondents.
Okay, and you have 5 minutes.
Thank you.
Thank you. The next case, People versus Young, is submitted. Torres versus Triborough Bridge and Tunnel. Appellant.
David Tolchin from Gerosalis and Jaros, Your Honor. I see. Okay.
You have 5 minutes and 2 for rebuttal and respondent.
Mary Ellen O'Brien for the Triborough Bridge defendants. I have 5 minutes for response.
Correct. Thank you very much. People versus David Rodney.
Gade Newland from the Office of the Appellate Defender on behalf of Appellant David Rodney.
Okay, we gave you 7 minutes and 2 for rebuttal. And People.
Yes, good afternoon, Your Honor. This is Milan Chachanda for the People.
Hi, and we gave you 7 minutes also. Gendel versus 42 West 17th Street, the appellant.
Jeffrey Mez for appellant cross respondent, Your Honor.
Okay, you have 6 minutes. And for the respondent's cross appellant, 42 West 17th Street.
Yes, hi, Alexander Fisher from Gartner and Bloom.
Okay, and you also have 6 minutes. Thank you. Jacqueline versus Charles N. is submitted. WDF versus Harleysville Insurance. Appellant.
Good afternoon, Sophia Uveda, Albalmedy, Fitton and Spratt for appellant.
Okay, you have 6 minutes and 2 for rebuttal. And respondent, Harleysville.
Good afternoon, Adenine Medina from Vigorito, Barker, Patterson, Nichols, and Porter for the respondent. 6 minutes, please, Your Honor.
Yes, that's what you have. Now, the next case is ZDG versus 310 Group. And let me just say that I gave all of the respondent defendants and third-party defendants 3 minutes. Really, you all seem to be in the same position. So in the next approximately 2 hours before we get to your case, I would ask you all to talk to each other, and maybe you can vote on somebody to make the points of the defendants, so we don't have to hear them 3 times from 3 people. And because I think I gave a little more time than we really need now that we've read all the briefs. ZDG versus 310. Is the appellant here?
Yes, Your Honor. Michael Strauss for Appellant 310 Group, and I'll take less than what I originally requested.
Yeah, I'm going to give you 5 and 2. Thank you very much. I appreciate that. And as I said, for the 3 defendants, I'd given you each 3 minutes. I really think that's unnecessary. So could you please get together, and by the time I call you back, you'll tell me how you've worked it out, and I trust that you will do that. So thank you very much. The next case is Soa versus Zabar, the appellant.
Yes, Susan Polovich Keaton for the appellant. I'll take 5 and 2, Your Honor.
Thank you. Very, very kind of you. We appreciate that. And the Zabar defendant respondents.
Good afternoon, Your Honor. Seth Weinberg from Morrow, Lilly and the party for the Zabar defendants. I believe we have 3 minutes.
I gave you 3 minutes, although you really seem to piggyback onto the main arguments from the third-party defendant, New York City Elite Gymnastics. Are you here?
Yes, Your Honor, yes, I could probably do it in 1 or 2 for the one point that's really different.
Okay, so you two talk about it. As I said, you have a couple hours offline, off the screen to talk about it. So I'll give you a couple minutes, and you know, if you don't want to both speak, that's fine too. Thank you for your courtesies. People versus Rosario is submitted. Iorfida versus the Department of Education. Appellant.
Frank Meyer appearing for appellant Iorfida.
Okay, we gave you 5 and 2. And the Department of Education?
Antonella Carlin for the Department of Education. I don't need 5. I mean, unless you have questions, I can take less than 5 minutes.
Okay, so we'll give you 3. And if we have questions, we'll keep going. Thank you. Thank you all for your courtesies. The next case is People of the State of New York versus Orbital Publishing. The appellant is actually Lydia Pugsley. Counsel?
Your Honor, David Lennon for Ms. Pugsley.
Okay, we gave you 6 and 2. And the People of the State of New York?
Caroline Olson for the state.
Okay, we gave you 6. Canzaneri versus City of New York is submitted. And the next 2 cases, Lerner versus Credit Suisse and Credit Suisse versus Della Russo. I see that there's the same lawyer for the individuals, but different lawyers for Credit Suisse, although there's a lot of overlap. I've given you 5 and 2 for both appellants and 5 minutes for the respondents. As I said, it'll be a long time before we get to you, so maybe you could talk amongst yourselves and try to, you know, narrow that down a little bit for us. I'm sure we would appreciate it. And that's that. So I imagine most of you are going to get off now. I just remind you to, in order to just make things go as quickly as possible, if you also make sure your equipments are good, make sure you're unmuted when you're supposed to be unmuted, muted when you're supposed to be muted. And, you know, come on as soon as your case is next up so we can move it along. And again, because we're on the computers, everything's been working much better now, but make sure that you don't talk over, certainly over any of the judges. So I think that'll be just fine. So those of you who are not on for a while, goodbye. We'll see you later. And the first case for argument is Mulgrew versus Board of Education.
Thank you. Good afternoon, Your Honors. I'm Thank you. I'm Christopher Lewis, attorney for the appellant Michael Mulgrew in his capacity as the president of the UFT. What the UFT is seeking in its underlying petition is simply the benefit of the bargain it struck with the Board of Education in July of 2016.
Counsel, this is Justice Moulton. You'd concede, as I think you do in your papers, that there's no retroactivity requirement on the face of the settlement agreement that you're relying on, correct?
Yes, the agreement does not explicitly indicate that there would be an entitlement to retroactive payments, but nor does it indicate there would not be an entitlement to retroactive payments.
I have a follow-up question. The section that you're relying on also refers to not only wages and salary, but also terms of employment, which of course is something that couldn't be retroactively given to anyone. And so the DOE makes the point that indicates that the section you're relying upon is not meant to be applied retroactively.
I think you can granulate that. There, certainly you can receive payments retroactively. That's what the mayor's personnel order did. Other benefits,
you can't like retroactively go back and change your conditions of employment. That's the point they're making, as I understand.
And payments is just one condition of employment. Certainly, if there was a mayoral order saying everyone gets a half hour extra for lunch, that would be something you obviously could not do retroactively. But payments are a different beast. Those can be given out retroactively as the non-represented employees received. Looking at that provision, that one part of that one sentence, if you read on, it indicates that the entitlement is to any future improvement made during the bargaining period. And any future improvement is a very broad term that would encompass retroactive payments or concurrent payments or hypothetically future payments that would take effect during a date within that 16-month bargaining period. And that's the important date, is the date on which the improvement takes effect, not the date on which the monies are actually received.
And of course, the problem is that, as you know, is that paragraph begins until an agreement is reached. And here there was an agreement reached between the UFT unit of AEOs and AEAs and DOE. So, of course, that's what you have to get around. And I'm so you go ahead.
So if you look at the agreement as a whole and you examine the context in which it was struck, it was in response to a representation petition that had been filed with PERB. And clearly the purpose of that provision was to keep the non-represented employees and the represented employees on equal footing during that bargaining period, and to read the agreement as permitting the Board of Ed to single out only the non-represented employees by doing so retroactively defeats that overall purpose of the July 2016 agreement.
So is the argument then that we should take away from the non-represented employees? Because according to the argument, the agreement, which was entered into in 2017 between Mr. Mulgrew and the UFT and the DOE, that ended the bargaining with the UFT and the DOE. Therefore, that in and of itself, according to the clause that Justice Moulton was referring to, that ended any increase that would have been given to the non-representative employees could not have been given to the employees represented by the UFT.
No, I don't believe the non-represented employees should have that pay raise taken away, of course. The way I interpret the settlement agreement from July of 2016, any benefit during the bargaining period that's given to the non-represented employees must also be given to the represented employees. Now, it wouldn't apply to the two other pay raises that were set forth in the mayor personnel order. There was another retroactive payment that goes to 2018 and another future payment that goes to 2019. We don't believe the represented employees would be entitled to that. We solely believe that retroactive payment that happened during the bargaining period, pursuant to the language in the settlement agreement, should have also been given to the employees who were on the verge or who were in bargaining to be included within the UFT unit.
Do any of the my panel members have any further questions for Mr. Lewis? Okay, thank you very much, Mr. Lewis. We'll hear from Mr. Shapiro.
Yes, good afternoon. May it please the court, Zach Shapiro for respondents. The board's decision here followed from the plain terms of both the settlement agreement and the personnel order. As some of your honor's questioning suggests, the agreement expressly limited any entitlement to benefits received. That's a negotiated term that the parties agreed to until an agreement is reached. And there's no dispute that this salary increase wasn't received until afterwards. Furthermore, they couldn't have been thinking about this applying retroactively because, as Justice Moulton's questioning suggested, it also applied to conditions of employment which couldn't possibly be retroactive. We're talking about a sophisticated party here in UFT. It negotiates these contracts all the time, and it knows about the possibility of retroactive salary increases, and we know that because they actually negotiated a retroactive salary increase in the MOA itself. So if they wanted retroactive benefits, they could have specifically negotiated that, but they didn't. I'd also be happy to address the personnel order, including its specific limitation to incumbents, which they don't even address, but I'll just accept any questions your honors have.
Does anyone have any questions? Okay, then I guess you had good briefs here. We'll take a look at them again, and I thank both of you very much for coming in this afternoon and for your courtesy. Have a nice afternoon. Next case is Al-Saud versus New York Presbyterian Hospital. Mr. Ratner for Presbyterian Hospital.
Good afternoon, Your Honors. Dan Ratner from Heidel, Petone, Murphy, and Bach. The petitioner would like to establish that my client's former patient was his biological father. So he has asked the courts in New York to order the release of a tissue sample that was left behind by the decedent at the hospital. Decedent and his family, of course, decedent or his family have not given permission for the release of that sample, and we have opposed the petition. The procedural history of this case is fairly lengthy and complicated, but the bottom line is this. There is no filiation proceeding pending. Well, there's no filiation proceeding in which the petitioner has been able to establish that this tissue sample has any relevance to. And the reason for that is because in Lebanon, the filiation proceeding has been dismissed on personal jurisdictional grounds by two different courts. And the reason for that is that none of the parties to that proceeding are Lebanese nationals.
But Mr. Ratner, isn't there an appeal pending at the moment, and it's not quite resolved until the appeal is resolved?
That is correct, Your Honor. But nobody disagrees that the petitioner is first going to have to overcome the jurisdictional hurdle on that appeal. Although new evidence, and we have.
Counsel, I'm sorry to interrupt. At that appeal at the Court of Cassation, there's a de novo review standard, is that correct?
I'm not sure about that. I can say, however, that what is correct, if that's what you're getting at, Your Honor, is that they can introduce DNA evidence at that point. Right. We don't deny that.
They can take new evidence at that stage. Right.
Having said that, nobody has denied, neither side has denied that evidence will never be ordered until the jurisdictional issue is resolved. So petitioner has taken the position, well, we can present this and sort of put the cart before the horse in Lebanon. That is not correct. But they first have to establish that the three parties to that litigation, none of whom are Lebanese nationals, somehow could get personal jurisdiction.
Judge Scarpula, may I interrupt you? On the 3102E only says that a foreign action has to be pending. And the petitioner put in an affidavit from a Lebanese lawyer which is unrefuted, that says that this action is pending because it's on appeal, and you're not disputing that, correct?
I'm not.
You didn't put in an affidavit from anybody saying, no, this lawyer is wrong. So as long as that affidavit is unrefuted, the statute's been complied with. We're not looking at all this other stuff. We're looking at our statute. Our statute says 3102E, foreign action pending. This has some relevance to that foreign action. We're done.
Well, Your Honor, you're right that it is a pending proceeding. We haven't denied that. However, there's been no order, no mandate, nothing, not even a hint by any court in Lebanon that this sample is material to that proceeding.
Well, is there a requirement? Does 3102E say anything about that?
Well, at we cited the Aliff case at page 17 of our opening brief, and numerous trial court cases, every one of which turned on the fact that the other court had issued something to the effect that the evidence sought was material to that proceeding. Here, that's never happened. And that's the position that we've taken, that despite the fact that there is a pending proceeding, there needs to be some imprint by the other court so that this court or the trial court in New York can defer to it. We don't take any issue with that.
Let me just ask you, there's nothing in the statute that requires that. And why not just have the discovery go through and then let the foreign court decide whether it's relevant? Why should we put that? To me, you're asking us to put the cart before the horse by saying we've got to wait for the Lebanese court to decide that issue first. No one's teed that up in front of the Lebanese court. We don't know anything about it. All we have is our own statute, which clearly you're conceding this is a pending proceeding and this information could be relevant in that proceeding.
The statute specifically mentions an order or mandate issuing out of that court. And I would say to your honor.
Can you tell me what you're talking about under
3102E?
Yeah, what
Counsel,
do you think requires it?
I think that the cases that have all interpreted 3102E have all relied on the fact that there's something coming out of that foreign court that says this is a material to that proceeding, and we're not going to second guess it. And if there had been an order or mandate, some sort of subpoena out of that court, then I would not be arguing this appeal right now. I would be saying your jurisdiction over this is somewhat limited.
But of course, I mean, we've already agreed that the reason there is an appeal is because the Lebanese court found that there was no jurisdiction. So they really didn't get into the meat of the matter. That's really not what the statute doesn't require that, as far as I can tell, looking at the statute.
And all I'm pointing to is the Appellate matter, where specifically this court rested on the fact that a California court had deemed the depositions that were an issue in that case as material and necessary to that proceeding, and we're not going to second guess it. There are also numerous trial court decisions which basically hold to the same effect. So I think that what we're seeing here is a situation where you have a pending proceeding that has been dismissed by two courts on personal jurisdictional grounds. And now, merely because it remains pending, without any court having ever said that this particular piece of evidence will have any bearing on the outcome of that proceeding, this court should basically stand in that foreign court's shoes.
Okay, thank you very much, Mr. Ratner. May we hear from Ms. Miller, please?
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honor. This is Hannah Miller from Hughes, Hubbard & Reed for petitioner respondent. As we just discussed, 3102E on its face plainly provides for disclosure upon notice alone. There's no requirement for an order or mandate, as the lower court held below. Just to address a few points that were just raised, it is true that the Court of Cassation, where the appeal remains pending, can accept new evidence and can also reach the merits of the case. And even if it is true that they would need to reach the jurisdictional issues first, that's not to say that they wouldn't then reach the merits of the case in the same breath. And so there's no reason to say that the jurisdictional dismissals below somehow render the DNA evidence that's being requested here outside the scope of the paternity proceeding that is pending in Lebanon. And again, the hospital does not dispute that there's a pending action, and it's clear on the face of the statute that when there's a pending action, disclosure is appropriate upon notice.
What about the cases that Mr. Ratner refers to that say that have interpreted to require something more than what the statute alone says specifically?
The cases that Mr. Ratner refers to are, in those cases, there happen to have been indications from the courts, the foreign courts, that the evidence in question was relevant, but that none of those courts require that or address the notice aspect of the statute. In ALIF specifically, the court did indicate that the evidence would be somehow relevant. It's not clear under what circumstances the court indicated that, based on the language in the case. But that was merely evidence that the evidence itself is within the issues of the pending proceeding. That was not a requirement for disclosure under the statute.
And do you have anything else? I don't think anybody has any questions. We're not usually shy about asking them. Anything further, Ms. Hannah?
Sure.
Ms.
I guess
Miller, I'm sorry, Miss Miller. I apologize.
no problem. Just to conclude, ALIF, that same case already sets forth the factors that this court should consider, and the court below considered those factors and properly concluded that disclosure is appropriate pursuant to 3102E. And in addition, the court indicated that even in the event of a dismissal, the disclosure could be appropriate under 3102C because petitioner is contemplating bringing an additional proceeding in the event that the currently pending proceeding is dismissed. And so we would ask the court affirm that conclusion as well.
Okay, thank you both very much. We'll take a look at that and appreciate your showing up today. The next case is 5 Star Contracting versus FIT. We will hear from the appellant first. FIT.
Good afternoon, Your Honors. This is, may it please the court, I'm Scott Matthews with Windell's Marks, Lane and Mittendorf. I'd like to focus on 3 issues before the court today. 1 is the statute of limitations, 2 is the extra work claims, and 3 is the propriety of the termination of the contract. Your Honor, we submit that the matter should be dismissed in its entirety because the plaintiff respondent 5 Star failed to name Fashion Institute of Technology until after the expiration of the statute of limitations. The lower court ruled that the relation back doctrine protected against dismissal because the 5 Star named various individuals associated with Fashion Institute of Technology and named the board of trustees. What it did not do, Your Honor, is name actually Fashion Institute of Technology.
But of course, that's true. But we saw that. But there seems to have been no evidence that I could find in the record to indicate that this was anything other than confusion on 5 Star's part as to exactly who is the entity they should be suing, and there was not a concentrated litigation tactic to not let you know your board got sued. I think that that's
to that point, Your Honor. I think that if the court looks at the record page 1045, you'll see 5 Star's principal testified at page 166 of his transcript that he knew his contract was with Fashion Institute of Technology. And if you also look at record page 322, Your Honor will see that Fashion Institute of Technology is identified as the party with which 5 Star is engaging into this contract. Each and every bid document identified Fashion Institute of Technology. The project is identified itself as Fashion Institute of Technology. The work was performed there, and under those circumstances,
this is Judge Scarpula. How does that show an intentional course to get some kind of litigation advantage? You know, the trustees were sued. It's not like someone who had nothing to do with this was sued. I'm sure there was is there any evidence other than we thought this was who FIT was? Were this board of trustees? Is there any evidence that the FIT itself as an entity was not sued for any kind of litigation?
I'm not aware of evidence demonstrating that it was a purposeful decision not to sue FIT itself. But there's also no evidence that this was a legitimate mistake. Rather, just that 5 Star may have been confused, even though it had actual knowledge that FIT was the proper party. But I understand the court's concern here.
All right. Well, Mr. Matthews, let's get on to, I think we have a few questions a little bit more into the substance of the issue. Okay. We were somewhat concerned, or I was somewhat concerned about the whole issue about whether or not 5 Star would have a right to cure, whether or not there was language ambiguous or unambiguous in the contract that required the owner, your client, to give a notice of a termination with a right to cure before you could terminate 5 Star as your contractor. So I wonder if you could address that.
Yes, Your Honor. Section 10.01 of the contract provides FIT with the opportunity to terminate the contract for cause, provided it does two things. It provides a written notice setting forth in reasonable detail the reason why for the termination, and sets forth a date certain upon which the termination would occur. The provision then continues to say that if the violation or the delay shall not cease, or arrangements satisfactory to FIT are not made, then the contract shall terminate upon the date specified by FIT. In this instance, Your Honor, FIT had been asking 5-Star to certify its payrolls for over a year and to provide evidence of proof of the disposal of debris in the proper manner. FIT, of course, is a public agency as a community college of the state of New York. It's bound by the New York labor law on a public project to make sure that that its contractors' labor costs are paid properly, that its labor is paid properly. 5-Star never provided this information. FIT identified that as the basis for the cause and identified the date certain that the contract would terminate that very day. The lower court below the lower court below held that that was inappropriate because FIT didn't give a reasonable opportunity to cure. There's nothing in the contract that provides a reasonable opportunity to cure. There's information in the bid documents that are not part of this contract that allowed for reasonable.
Are the bid terms and conditions not part of the contract? That's your position, correct?
That section P is not part of the contract, but even if it were, Your Honor, section 2.2 states that the general conditions govern over any dispute between the bid documents and the general conditions. That's at the record page 170. And in this instance, Your Honor, we would also submit that even if had FIT given an opportunity to cure, it would have been futile, given the fact that 5-Star had refused to comply with its contractual obligation to provide certified records for well over a year.
Counsel, let me ask you this: did FIT even argue that section created a right to cure?
Did FIT or did 5-Star?
I'm sorry, did 5-Star
even
argue that section created a right to cure?
There was
in their papers?
I think it was at oral argument, Your Honor. I'm not sure.
Not in their underlying, right? Because I didn't see any argument to that effect in the underlying papers.
No, but the trial court below included a footnote in the order addressing that section, and so that's why I raise it now. But in any event, it's section 10.01 is the governing section, and in it does state that there's an opportunity for the violation to cease. It does not require an affirmative opportunity to cure on FIT's part.
And these are two sophisticated parties, right? If they wanted to actually have a notice of cure and a cure period, they could have said 30 days. What we would see would be a normal cure provision, right?
I think they're absolutely sophisticated parties. It's a multi-million-dollar construction contract, and the fact that the reasonable opportunity to cure was part of the bid documents but not incorporated into the contract suggests even further that 5-Star knew when it entered into the agreement that it was not entering into an agreement that allowed for an opportunity to cure. I know
your time is up. You do have a few minutes for rebuttal. I'll
cede my rebuttal time if I could just speak very quickly to the extra work claim, because I think that's extremely important, Your Honor. The New York Court of Appeals and AHA General Construction ruled that where there's a contract that provides for extra work claims being submitted in writing on a condition precedent basis, meaning that they be submitted prior to the work being performed or within a certain time period, that the court must strictly construe those types of conditions and reject any extra work claim where it's not complied with. Here, it's acknowledged that 5-Star never provided an extra work claim in writing. It certainly didn't comply with it on a timely basis.
Well, counsel, AHA has a slight carve out for that, which is that if FIT in this case prevented or hindered compliance with the change order procedure or the extra work procedure, however you want to call it, then possibly 5-Star did not have to comply.
AHA has that carve out, Your Honor, but I don't think there's any evidence that that FiveStar prevented, that FIT prevented FiveStar from issuing a written change order. FiveStar submitted some writings months later. The requirement under the contract at section 11.01 states that FiveStar must submit written extra work claims within 15 working days of being tasked with or commencing the work. The earlier of that, or the claim is waived. 11.01b subsection 2 specifically says that the claim is waived. The Barsardi's decision that the lower court relied upon, that this court held in 1998, specifically pointed out that it's distinguishable from AHA because the notice provision didn't have such a express waiver condition included within it. Unfortunately, the motion court didn't even address this binding Court of Appeals precedent, which we submit puts this issue to rest.
All right. Thank you very much, Mr. Matthews. We'll hear from Mr. Bink, respondent for FiveStar.
Yes, great. Thank you, Your Honor. With respect to AHA, I think that the hard line being drawn, FIT is drawing a bright line that I don't think that AHA draws. AHA did a factual analysis in that case and found that there was no evidence of a course of conduct which would take it out of the scope of the waiver provision. This bright line that that FIT argues simply doesn't exist. The court wouldn't have gone through the analysis of whether or not there were facts supporting the claim and concluding there was no showing of the conduct complained of. That was what they did. They did not create a bright line.
Counsel, for hypothetical sake, let's just say that they did require this prevent or hinder compliance with the change order procedure. In what way did FIT prevent or hinder your compliance?
The change order provision was controlled by RAND Engineering, FIT's agent and engineer on the site. All change orders originated with RAND. And they would be submitted to FIT, to FiveStar, and then submitted to FIT later. That was the procedure. There were 36 change orders on this job. Not a single one of them was done before the work was done. Every single change order was after the fact. The parties would meet, they'd say what needed to be done, they would agree on a price, or not necessarily agree on a price, but just say, we'll get compensated for you, we'll figure it out later, but you have to do it.
Yeah, but you're talking about course of conduct now again, and I was asking you about prevent or hinder.
Well, that I think it's all related because the prevent or hinder starts with RAND Engineering. If RAND doesn't start a change order process, or does, and then FIT reneges on it, that is a prevent or hinder, and that's what happened here. Particularly, there are two change orders, and there are two changes in particular that FIT is complaining about. They're the assisting, the facilitating RAND in its scoping. This is the outside of the building, and RAND asked FiveStar to ferry it up and down the building when the job started. RAND said, don't submit a change order for this. We'll pay you. We'll give you $5 a square foot. You know, it's outside the scope of your job. We know that, but we don't want to start the job with a change order. So they did. And in fact, FiveStar got paid for one of the buildings that they did that on. And then FIT later on sought to renege on the agreement. A new engineering team came in and wanted to do all that same work again and insisted on doing it even a different way that was more expensive with scaffold drops, which cost a lot more money than bringing somebody up on a boom lift, which was what the first job did. And they agreed to pay $6,000 per scaffold drop. Again, they didn't agree to do it at the time. They said, we'll figure out the price later, but we got to get this done. We want new work done. So the new team had it done. They agreed, and they paid on one of the buildings again. They paid for the scaffold drops, but then they reneged on the rest of the buildings. Now, I think it's also important to note, though, that in the stipulated facts in this case, the 6 buildings that were completed and accepted by FIT. You can't have a breach of the contract with respect to to that work. They accepted the work. So I think it's important to note that with respect to this, there's clearly a course of conduct here. But also there's interference by RAND and FIT in seeking to renege on the agreement after the fact. Now, the dispute provisions, which counsel refers to, don't really apply because there was no dispute. And that section of the contract is titled dispute. There was no dispute. Rand agreed to pay. So this is just a case of FIT seeking to get free work that we were not obligated, that 5-Star was not obligated to do.
Does anybody have any further questions for Mr. Vink? Mr. Vink, did you have anything else that?
I did. I wanted to briefly touch on the termination provision because I know that was questioned by the court. Yes. There are two provisions in this contract that require giving notice and an opportunity to cure. It's not reasonable to read the contract any other way. The second one, which Mr. Matthews didn't really discuss, is attached to the contract, physically attached. And these
Counsel,
provisions.
This is Judge Scarpula. Is that document listed as one of the contract documents?
The contract, the description of contract documents uses the word attachments.
So I'm asking you specifically, again, it's a real simple question. Is that one of the documents that is specifically listed as part of the contracts? The terms and conditions?
I don't mean to be argumentative, but it was attached.
I just want to know, there's a list of, these are the list of what has in the contract. Is terms and conditions one in there?
It is not, but that list does say documents that are attached.
Let's keep going, right? So these are two sophisticated parties, right?
Mm-hmm.
And everybody knows how to write a cure provision. I mean, second-year law students know how to write a cure provision, correct?
Your Honor, these contracts aren't
a main contract that has what we would call a standard cure provision?
These documents are not negotiated, Your Honor. They're given to the party. This is a one-sided deal. My client's negotiated in the fact that he has 35 years of experience doing facade work, largely for municipalities. But these contracts are not negotiated contracts. The prices are negotiated. The terms are whatever FIT or the government says they are. And then they give you.
So that means that if FIT doesn't put in a cure period, a clear cure period, there's not a cure period, right?
There's still, I disagree, Your Honor. I think the court was absolutely correct in finding that you have to have a reasonable opportunity. FIT was physically on the job when they terminated this contract because FIT didn't give them paperwork. So I don't think that's a reasonable position for FIT to take.
Even though AHA says strong public policy considerations favor those kind of claims when offered by contractors to excuse non-compliance with notice and reporting client. I mean, the Court of Appeals, I think, says something different, right?
I think that if you're talking about a material breach.
No, I'm talking about, you're saying it's just paperwork. I'm saying the Court of Appeals says there are strong public policy reasons to require that just paperwork, right? That's what I think AHA says in public works contracts, at least, right?
I think the distinction is, and I agree, there's certainly a requirement that they keep these records. There is no dispute about that. But the fact is that 5-Star could provide the documents, and they were never told we're going to terminate your contract if you don't give us these until the day they got the termination letter. They were asked for them, and it's admitted by FIT's primary witness that they don't ask for these until they're looking for a reason to terminate someone. Now, that doesn't excuse us from not giving them to them, but it's a tactic used by FIT in their internal dispute practice. And he admitted that we don't ask for them until there's a dispute. Okay. And it wasn't a dispute about those documents.
Okay, I think you've answered all our questions, and I thank you both very much. We will take another look at these issues, and thank you very much for showing up this afternoon and for your arguments.
Thank you.
The next case is Kopolovich versus 200 Water. The appellant, Mr. Seidenstock.
Yes, Your Honor.
Okay, go ahead.
I think the main issue that I want to raise in this case is that the plaintiff's position is that Exhibit L, which is a photograph that was admitted into evidence, should not have been admitted as it wasn't properly authenticated.
Well, but Mr. Seinstock, let me ask you, I have a copy of Defendant's Exhibit L, and I also looked at Defendant's Exhibit K, which I think was the black and white version of this colored version of the picture. And it was, didn't the parties stipulate that Exhibit K was okay? So what could possibly be so prejudicial about Exhibit L?
Exhibit K was not admitted into evidence.
But the parties agreed to that. They stipulated that was that they could use that during the questioning. Wasn't that true?
I don't think so. I believe that the evidence shows that the court ultimately gave the jury a curative instruction. I think it's on 951 of the in the page between 951 and 941 and 955 of the transcript. Of the record, where they discussed the admissibility of this photograph, and the court said, well, I'm not going to let the jury see it because there was a dispute as to whether or not it was, admissible, because the plaintiff said, well, I don't know who took this photograph, and it doesn't look familiar because the sign that, was showing in the doorway wasn't there when I, had my accident. So I think that's the issue, is that the court had said I'm giving you a curative instruction to the jury, you can't consider this photograph, but then it subsequently admitted the same photograph for,
Well, this is Judge Scarpullo. I think my recollection was that Exhibit K was stipulated to and moved into evidence by stipulation. And maybe are you disputing that?
Well, I don't know if it was moved into evidence. It was
stipulated into admission into evidence. Exhibit K, the black and white photo, right?
But then the judge gave a curative instruction and said the jury shouldn't consider it.
To the colored photograph, because that hadn't been stipulated to, right?
Well, yes, that's true.
So the question then, I guess Judge Kapnick was asking is, if the black and white photo, which is almost exactly the same, is in evidence, what is the big deal about the colored photograph? What's the prejudice?
The colored photograph is much more, detailed as far as the ability for the jury to look at it and see, what's going on in the
well, isn't the issue
also that
Mr. Seinstock, was the issue about these photographs was that there was this yellow sign up here, a yellow sign in the back that may have, honestly, I can't read what it says, but it looks like a sign you might put up if you were cleaning the floors to say wet floor, which I think is it. Now, she was able to testify, your client, that this was not exactly how it appeared at that time. That sign wasn't there. I mean, she was able to testify to those things as to her questioning as to whether the sign was exactly where the defendant suggested it was, although this was obviously taken right after she fell because she's lying on the floor, the hospital bed or gurney that they were going to take her out on is there, and the EMS is talking to some of the other witnesses, I think the son, the roommate. So I mean, she was able to do it. I'm trying to figure out what's the prejudice, since she was able to testify that no, that isn't exactly how it looked. That sign was a little bit in a different place or something. It had been moved.
The point is that they admitted the one, and then they then admitted this yellow photograph, which was a different photograph, and she's basically saying, well, that photograph is not I don't recognize it, and they should have had someone come in and authenticated that this is what was shown at the time that the accident occurred.
Okay, are there any other points other than the photograph that you want to make? Because you just have another minute.
I mean, the other thing is that even if you accept the fact that this sign was there and she should have seen it, the question becomes that she went in and out of this store all day long and had never had any problem. No one ever challenged her to go about the use of the door. And then at the time she went out and slipped, the handyman claimed he had washed the floor an hour before, and she said, and the incident report said he had washed it a few minutes before the accident, and subsequently, there was an issue as to whether he actually said that he only had one wet floor sign outside the door of the garage and not in the door to the entryway. So, the problem with the photograph and then the discrepancy in all the testimony, the jury, I think, was, prejudiced in some way by, the fact that, they saw this sign in the color photograph and they said, well, it must have been there. But, I just think overall, the failure to not allow that into evidence was
okay. You'll have 2 minutes on rebuttal. Let's hear from the other side first. Thank you.
Good afternoon. May it please the court. My name is Stephanie McDougall. I'm with the law firm of Dorff and Nelson. I represent the respondents, 200 Water Street and Rock Rose Development. Just to respond to what appellant said, a critical issue at this trial was whether or not the plaintiff exercised reasonable care while walking through the loading dock area, which was restricted to authorized personnel. The jury heard conflicting evidence with respect to whether or not the caution signs were placed before or after the fall. As the court noted, Exhibit K, which was admitted into evidence, is nearly identical to Exhibit L. Exhibit L was properly authenticated. Ms. Kapalovich said, defense counsel asked her, is this a fair and accurate description of the accident scene after you fell? And she said the accident scene, yes. Plaintiff,
what did she go on to say after that? Didn't she say certain things were moved or that weren't exactly like she remembered it?
Correct, but that goes to credibility, which is a jury function, and the appellant is impermissibly attempting to transfer the weighing of credibility of evidence from the jury to the court.
Because Mr. Valerio did say that he put down warning signs, correct?
Yes, he did.
Can I ask you a separate question, counsel? Was it against the weight of the evidence for the jury to fail to award lost earnings from 2011 to 2014? Because the evidence was kind of unrebutted that she wasn't able to work full time during that period. So how do you explain that?
At the time, there was conflicting evidence with respect to the extent and permanency of her injuries. The defendants called experts which testified that she had a hamstring tear. She was out of work from July 29, 2011. She returned in November of 2011. The plaintiff testified she did not have any loss of earnings during that period of time because she was receiving disability. The plaintiff contended that as a result of the hamstring tear, she had a gait disturbance which caused injury to her right knee, which the defendants refuted.
Also that she tried jobs and that she really couldn't do them, especially the limo job. So in other words, what's to rebut that she couldn't work full time during that period? How could the jury not award something for lost in that period?
In looking at her tax returns for that period, the plaintiff's income was a combination of her salary and her commission. And she did not break down which part of her income was salary and commission. She earned commission through leased properties. So it's our position that she didn't plead it with specificity sufficient to show that her income was impacted.
Well, we're talking about the proof at trial, of course, at this point, not about what's pled.
Right, but but there was evidence for the jury that her hamstring injury fully healed with conservative treatment without permanent injury. So she was able to return to work in November of 2011, where she worked full time once she returned. She was subsequently terminated from that position, but she didn't offer any testimony with respect to how the claimed injuries impacted or affected were a cause of that termination.
Well, what was part of the issue that the problem developed later when she claimed she had a problem with her knee, and there was conflicting medical testimony, I believe, between the different experts as to whether or not the knee injury had anything to do or was causally connected to the accident. That's the way I understood it.
Correct. And she did have a May 25th of 2014 injury where she was working as a limousine driver and her right knee buckled while walking down a staircase at Newark Airport. There was also evidence before the jury. The plaintiff was cross-examined with a Facebook post she wrote regarding a trip she took to Panama in 2017, where she participated in activities. She wrote she walked 10 miles a day. She fell. She closed the car door on her right knee. This is a very different picture than what she portrayed at trial with respect to her injuries and what she can and cannot do.
Okay.
So you're saying that could be used to undermine her credibility, and if she's the only person testifying about lost earnings between 2011 and 2014, that the jury was entitled to discount that testimony?
Yes, Your Honor.
All right. Thank you very much, Mr. Seidenstock. You have 2 minutes for rebuttal.
On the issue of her comparative negligence, it's clear from the testimony that she and her son were never challenged when they were walking back and forth through this area that was supposedly restricted. In fact, Larry testified that he never saw them going back and forth, and then he allegedly only saw them right after or right before the accident. So, I think Valerio's testimony as to who had access to this area is highly suspect. The other thing with the lost earnings, she did establish her lost earnings through her own testimony. The defendant didn't, show that there was any basis not to award her some sort of lost earnings. And this Facebook post was from much later on, and that had nothing to do with her lost earnings. It might have something to do with future damages, but certainly as to past damages, the amount awarded was substantially less.
Well, we give a falsus in uno charge in all of these cases. I haven't tried a jury case in a few years, but I remember giving that. You tell the jury if, you find that the client or the witness testified untruthfully about one thing, you can assume or you can consider that they may have testified untruthfully about others. So we know that does happen in a trial.
But in this case, they did. It's not that they came away and simply said she wasn't injured or the accident didn't happen or there were no damages. They did award her $100,000.
Well, the accident certainly did happen. We have pictures.
Right. And they did award her damages, so they must have believed that she was injured. So, I think.
Okay, well, we'll take a look back at your briefs, and I thank you both very much for the arguments. Have a very nice afternoon.
You too.
Next case is Torres versus Triborough Bridge. Appellant plaintiff, you have 5 minutes. Good afternoon.
Good afternoon, Judge Kapnick and David Tolchin for Gerosalis and Jaros for the plaintiff appellant. I think there are 3 fundamental mistakes that the court made below. Let's like to name them. The first one was the plaintiff did not choose to leave the debris in the roadway. The plaintiff was told to stop cleaning. His job assignment was interrupted, and he went to do a different job assignment because that's what his foreman told him to do. The work he was doing was no longer cleaning, but he was assigned. He was no longer cleaning in that area on the roadway. He was assigned to a different area.
Well, he was helping his foreman build a fence with some plywood, right? He went over the Jersey barrier to get the plywood, if I understood the facts.
That's correct. He went over the Jersey barrier. At that point, he had no access, and he couldn't clean the roadway.
But counsel, was the plywood to make sure that debris from the overhead work didn't go onto the roadway? I mean, that was the purpose of him getting the plywood and the purpose of the fence, correct? Or am I mistaken?
Well, that's what his understanding was, Your Honor. And I might add, that is not removal of debris. That's not cleanup
I'm just saying
debris.
that debris was happening as a result of the work. We're talking, if you want to talk about the industrial codes, I mean, talking about 1.7E2, the question is that inapplicable because debris was resulting from the work being performed at the time. And so he wasn't doing the work, but a bunch of other guys were doing the work. And in fact, he was doing ancillary work to help contain the mess created by the work that they were doing. So
I mean,
that's
they were doing demolition work. That's what they were doing. He was doing, as Judge Moulton said, he was doing something ancillary to help try to protect the debris from falling onto people and cars and other things that were in the street, right?
Yeah, well, again, that's not removing debris. That's preventing new debris from falling down and bouncing into the active roadway. It's not what his job assignment, they claim, was, which was removing debris. And logically, he had nothing to do with that, other than moving the plywood, handing it over the Jersey barrier to his foreman and his coworkers. Logically, nothing he could have done would have prevented his injury.
Counsel, this is Judge Mendez. I have a question.
Yes.
He had to go over the Jersey barrier. And before he went over the Jersey barrier, he saw that there was debris on the ground, correct? He went over, he picked up the plywood. He then handed over the plywood to whomever was there with him, whether it was his supervisor or whomever. And then he decides that he's got to cross over the Jersey barrier again.
No, Your Honor.
No?
I'm sorry to interrupt. He didn't decide. He was told to climb back over, and he stepped over on instructions from his boss. And
did he have to climb back over the same exact spot, or could he have climbed over at some other location where there was no debris?
The debris that fell while he was working on the other side of the barrier. He was there for 20 or 30 minutes, however long. He was. He did not have to climb back over exactly.
On the ground, if there's debris on the ground at the spot where he wants to climb over the barrier, can he move over a couple of feet and climb over the barrier where there's no debris?
It sounds to me like you're asking, was he at all comparatively negligent in failing to look at where he was stepping before he got over? If that's the case, that's not a reason to dismiss the action. That's a question of damages. It's a question of his comparative percentage of fault. It's not a reason to dismiss, and it wasn't the reason the court below dismissed. And I should also add there, he did not say that there was specifically debris exactly where he stepped over when he was on the roadside. He said there was debris generally all over the road. It was falling down all the time, all over the road. And when he climbed over, 20 or 30 minutes later, or however long it was, then he came back, more debris had fallen, and he never testified, well, I saw the debris at that point, and I intentionally made sure to step exactly where I knew there was debris. He never said that. He came down, and his foot happened to trip over the debris, and he fell and got injured.
All right, you will have 2 minutes for rebuttal, Mr. Tolchin. We'll hear from Ms. O'Brien. Good afternoon. Whoops, wait, you're muted. You're muted, Ms. O'Brien.
Okay. I'm Mary Ellen O'Brien. I'm here for the Tribo Bridge and Tunnel defendants. It is our position that the integral to work defense was applicable here, and under that defense, the industrial codes that plaintiff relied on, 2317E1 and 2, are not applicable to sustain a cause of action for labor law 240.
Ms. O'Brien, did it matter what exactly Mr. Torres was doing at that moment in relation to the debris, whether he was actually sweeping the debris or doing something ancillary to cleaning up the debris at the moment that he was injured?
According to this court's case in Krasnowski versus the City of New York, relying on O'Sullivan versus ID Construction, it's not necessary that his specific task is what was related to the injury. It's the nature and condition of what they're doing. He was part of a group. His foreman and another coworker and he were all maintaining and securing the street. Part of that maintenance was he was called over to lean these, it wasn't even a fence, they're leaning these plywood things along the barrier so that it bounces into that area and saves the people who might be walking or cars. It was all the same. He would have been cleaning up that debris afterward if it was small enough debris. I mean, the bottom line is they were all involved in securing and maintaining the street during this demolition operation. And that was the very work he was supposed to do. When he climbed over the barrier the first time, there was debris on the ground. He saw it, he pushed it aside and walked over to help his foreman. When he climbed over the second time, his testimony is very clear. He did see the debris there on the blacktop gravel that they had put there, and he put his foot down on it. I don't know whether there was debris further down or less, but he knew that debris was there. He just stepped on it and turned on his ankle. And under those facts, that is the debris, that is the work he was supposed to be prosecuting. And that is not covered under the integral to work defense for these two. And that is the only two regulations supporting the 241 sub 6 claim, and they're not applicable under these facts.
Does anyone have any further questions for Ms. O'Brien? Okay, well, I think we got your arguments pretty clear cut. So thank you very much.
Your Honor, can I rebut?
Yes, yes. You have 2 minutes, Mr.
Thank you. Ms. O'Brien said that the testimony is very clear. However, her recitation of that testimony was incorrect in the record. I would ask the court to please read pages 392 of the record and 321 to 323 of the record. It never says that the plaintiff looked down and saw the debris and kicked it away. Never says that. I don't know where that information comes from. It's just not the case. Also, the debris was not a gravelly asphalt. There was asphalt. It was an asphalt patch that the actual Jersey barrier was affixed to the ground with, and up top of that patch of asphalt, which was hard and solid, was the debris that had fallen after he had left the area.
I took a look at 320 to 323, and this is what I wrote. According to what, I mean, and I'm paraphrasing, I don't have the transcript in front of me. Saw debris before climbing barrier, didn't clean it, stepped on same debris, climbing back.
Before he climbed over the first time. The first time meaning before he climbed into the storage area. 20 minutes later, he climbs back, and it's still before. That's what he's referring to.
Well, I read it, and this is what I came away with it.
Read it in context. It's extremely clear to me.
Yeah.
Thank you, Your Honor.
I think I did. Thank you.
Okay, any other questions? All right, thank you both very much. We'll take another look. Thank you. The next case for argument is People versus Rodney. Counsel for Mr. Rodney?
Yes, Gabe Newland from the Office of the Appellate Defender on behalf of David Rodney. At every stage of this case, Mr. Rodney's lawyer failed to provide meaningful representation. He failed to pursue a winning argument to suppress the heroin. He failed to object to the trial court's improper jury instructions.
Well, wait a second. I'm sorry to interrupt you, but why are you assuming that that was a winning argument to suppress the heroin? I mean, the testimony of the EMT was that he actually saw the packets of drugs in the defendant's pocket while in the ambulance, that the police never said, oh, by the way, when he gets into the ambulance, take the drugs out of his pocket. That was his testimony. So, I mean, he might have been able to make it, but I'm not I'm not so sure that that was a clearly winning argument at any level.
I think that there was a very strong argument to suppress the heroin, both at the time of the suppression hearing itself, and certainly once EMT Paulino later provided trial testimony that contradicted the basis of the suppression court's order. So the suppression court concluded that first, EMT Paulino wasn't a state actor. As we explained in our briefs, that conclusion was clearly wrong. He was a
what?
state
I'm
actor.
sorry, that Paulino wasn't what?
The suppression court concluded that he was a private citizen to whom the Constitution did not apply. And for the reasons we explained in our briefs, that conclusion is wrong. The Fourth Amendment applied to EMT Paulino. As to the question—
This is Judge Scarpula. Didn't trial counsel argue that in his omnibus motion?
The first lawyer—
Isn't that exactly what he argued? That he is a state, that the EMT was a state actor, and therefore there should be suppression?
Mr. Rodney had two different lawyers. His first lawyer filed an omnibus motion that raised the state actor question. Then at the partway through the suppression hearing—
That was raised, right? So it can't be ineffective to not raise it if it was raised.
So let me clarify. It's not that the second lawyer never made any argument at all. It was ineffective for him to not pursue this argument. At the conclusion of—
There was a motion made and decided with respect to that argument, correct?
It was
made and it was resolved. So I'm not sure how you can say that it was ineffective.
It was ineffective because that first motion was before any testimony was developed at the hearing and then later at the trial. And so once the testimony comes out at the hearing, there was a very strong argument to suppress the evidence. And then later, once EMT Paulino's trial testimony undermines the basis of the suppression court's written order, then there's a very clear argument to suppress that. So first—
Okay. How are you saying that the EMT's testimony did not comply with what the court said? I don't understand what he said later that wasn't consistent.
Sure.
Could you point that out to me?
Yes, let me explain. So at page 5 of the suppression court's order, when it's concluding that the evidence is in plain view, it said, quote, Paulino testified, I could see it clear as day. The front of each triangle packet said RIP and had a picture of a tombstone. Later, at trial, EMT Paulino admits that he could not, in fact, see those labels clear as day, as he had testified at the suppression hearing, and which the suppression court relied on. Instead, he said, I couldn't see that labeling until I had already pulled it out of Mr. Rodney's pocket. At this point—
But he did see the packet sticking out of his pocket, even if he didn't see, it wasn't clear to him what exactly the logo or the RIP, notations on those envelopes said. He did say he saw triangular pockets that he knew would have to be drugs. That's sticking out of his pocket. He did say that.
He said that, but this is a very important distinction. If he can see some wax paper and some plastic, this doesn't provide probable cause that this is some kind of illegal substance. EMT Paulino says, I thought it was some form of drugs, but he doesn't describe this as, he doesn't identify this as glassine envelopes. Unlike other witnesses who testified at trial, he doesn't describe any kind of training or experience that would actually support the inference that there's any kind of correlation between glassine envelopes and heroin. So what he can see is he's sitting on the bench of an ambulance. He can see that there's some packages, sort of hanging out of Mr. Rodney's pocket, but he just identifies that as some plastic. That's not criminal. And so it's not until that he pulls it out of Mr. Rodney's pocket and sees that it has these suspicious labels, is there an argument that this was actually in plain view? But we know based on his trial testimony that he couldn't see that until he already pulled it out. And so I think that, based on the lack of training and experience he had relevant to the identification of narcotics packaging, there was a strong argument that this wasn't in plain view at the suppression hearing. And then when he gives this subsequent trial testimony, there's a very strong argument to reopen the suppression hearing. But if the court isn't inclined to reverse Mr. Rodney's convictions because of the suppression error, it should remand this case for a new sentencing hearing, including a new predicate determination. Once Mr. Rodney's first lawyer had presented what the trial court agreed were very serious allegations of a faulty homicide conviction, the court couldn't legally steer away from questions about the homicide. It had to hold a
But
hearing.
I thought that the judge relied on a different conviction of a first-degree robbery and second-degree assault, and not upon this somewhat questionable August 1981 conviction for the attempted murder. So he didn't base it on that, was my understanding from reading the testimony.
Sure. So he relied on a robbery conviction from the early 1980s, but as a legal matter, because that conviction was more than 10 years ago by a lot, the only way that that conviction satisfies the legal definition of a predicate felony conviction is if there is a legally valid conviction to toll the 10-year limit on predicate felonies.
Well, he was imprisoned for like 27 years, I think.
That's correct. And before trial, Mr. Rodney's lawyer had presented what the court itself acknowledged were very serious allegations that that conviction and Mr. Rodney's decades of incarceration on that conviction was unconstitutional. The law is very clear that if the conviction is unconstitutional, it can't provide a basis for tolling that 10-year limit. And so at the very least, the court couldn't just steer away from this conviction and say, I'm just relying on the 1980 robbery conviction. It had to decide.
Counsel, let me just interrupt you. Didn't he get incarcerated? Wasn't he incarcerated for that conviction?
He was incarcerated for the homicide conviction.
No, for the robbery conviction.
He was incarcerated for the robbery conviction.
So why couldn't the court use that robbery conviction incarceration period as the predicate tolling time?
Because he was only incarcerated for 4 to 12 years on the robbery conviction, and there were still many decades after that. The trial prosecutor himself at the pretrial hearing concedes that the homicide conviction is necessary for the robbery conviction to be a valid predicate. So that wasn't in dispute. The question was just whether the trial court had to decide whether the decades of incarceration on the homicide was a valid tolling period. And so because that there was a serious allegation that decades of incarceration were unconstitutional, the sentencing court had to decide whether that tolled.
Wait a second, let me just interrupt you for a second. Didn't the people file a third predicate felony statement? So I don't know where in the record did the DA say, if the homicide conviction is no good, then we lose on this? Because I didn't see this. I thought what they did was file a third predicate felony statement, which dealt only with the robbery to avoid that whole problem.
So
where is it in the record where the DA says, if you find that the murder conviction is unconstitutional, then the robbery conviction is no good and we're sunk?
So at a pretrial status hearing,
can you just cite the part of the record? Because when I looked through the record, I didn't see that.
Yes, it's a pretrial status hearing on March 2nd, 2016. It's on the 4th page of that pretrial status hearing. The court asked the prosecutor, can you remind me, does the robbery conviction qualify as a predicate only if the homicide is included for purposes of tolling? And the prosecutor says yes. He then argues that Mr. Rodney's decades of incarceration on the homicide tolls the robbery, even if the homicide is found unconstitutional. As we explained in our briefs, that is clearly wrong. And the court responds to the prosecutor by saying, that may be an issue, but we'll discuss that if it's an issue to discuss. Then, at sentencing, the court never returns to this question, and Mr. Rodney's new lawyer never brings it up again. And so I think, as a standalone claim, the court erred by failing to revisit this predicate question. And Mr. Rodney's lawyer was ineffective for not asking the court to revisit, particularly when combined with his other errors of failing to pursue the suppression argument.
Okay, you will have a couple minutes for rebuttal. Let's hear from the prosecutor's office. Thank you, Mr. Newland.
Thank you.
Sure. Good afternoon, Your Honor. May it please the court, I'll start off with the ineffective assistance of counsel claim at the suppression hearing. I want to note at the outset that there was no 440-10 motion here, and that was so it's not properly before this court. And I think that's really relevant because not only was counsel not afforded the opportunity to explain his action, or in this case, inaction, but also that was all the more reason that he needed to explain, given that he provided very solid representation throughout the rest of the trial. And I will explain some instances there. But for now, I'm just saying it's properly not before this court. But in any event, the record, to the extent it permits review, there are two bases for denying the suppression motion. First and foremost, the EMT in this case was not a state actor, as the court properly found. Now, what defendant is arguing is that based on his status alone, just that he was an EMT but employed for 4 years by the fire department, that status alone was tantamount to state action. And that's not the law in this case, in this state, excuse me. The law focuses properly on the action. And the action here was not done at the behest, with a cooperation, or in any kind of connection with the police, and that was.
And there was no there was no testimony, was there, from any police officer that gave any suggestion that perhaps there was any indication? I mean, this was a position that the defendant took, but I thought that the police officer said we never told him anything about that. I mean,
exactly. There were actually two separate police officers who explicitly testified that neither they nor anyone who's there, another police officer, had any kind of even connection with the EMT. So that was the primary basis. The alternative basis for the court was that it was found in plain view. Now, at the suppression hearing, the EMT said, yes, I saw it clear as day, but he said, I saw it clear as day that it was this package. And I've had experience with people who have drugs in their system, I've seen drugs in their possession. So he said, I saw it clear as day, this package. And then he did say, I saw also the RIP logo. Now at trial, notably through the cross-examination efforts of this defense counsel, EMT had to clarify that he did not see the RIP until after he pulled it out. But he was adamant that he's always knew that what he saw, he suspected to be drugs, whether or not he saw the logo or not. And that's what's dispositive, because the plain view doctrine does not require absolute certainty as to the legal nature of the drugs. He had a reasonable basis for believing so based on his experience and for what he thought. So the RIP is kind of a red herring, and there was no basis for an opening of the suppression hearing.
Now, what about, I'm curious about the points that Mr. Newland also spent a lot of time on talking about, the predicate felony convictions, because was the fact that he was sentenced for such a large period of time was not based on a first-degree robbery conviction, but wasn't it based on the murder conviction? And doesn't that raise a problem here?
Okay, Your Honor, I do want to make it as simple as I can, because I do think it's really a simple issue. Penal Law 7006 1B5 says tolling encompasses any period of incarceration for any reason, and that's proper tolling. Now, let's step back, and the predicate that he did not challenge, that he admitted to, was first-degree robbery. So that there is no issue with that conviction. Now, in terms of tolling, any period of incarceration that for any reason. Now, in this case, yes, he filed a 44010, I believe 44010 to vacate the underlying murder convictions. But I mean, we argue that that case, that 44010 was denied. But even if, let's say, it's still pending, the incarceration period has never been deemed unlawful by any court. Especially the court in which it's properly before, the Brooklyn Kings County Court. So that period of incarceration, according to Penal Law 76, says any period of incarceration for any reason. So once that, even though the predicate has been challenged in a 44010 motion, that's not the predicate the court relied on.
What do you mean, if even assuming it wasn't decided? I mean, where is it? It either was decided or it wasn't decided. I mean, I read that in the papers. I was a little unclear as to the status of that.
Yes, it's very confusing, Your Honor. According to the papers below, it seems defendant has made the claim that it's still somehow pending before the Brooklyn court from 2009, which was the last status update.
2009?
2009.
Okay.
Yes, whereas our position has been based on court records, and this is all in the record in this case. Our position has always been that on the date that there was supposed to be the sentence the motion was supposed to be adjourned to, it says sentence continued, which according to our discussions with court officials, sentence continued means that the 44010 was denied. But let's say we hold what defendant says to be true and that it's still somehow pending. That means that the period of incarceration has never been held to be invalid. The court that's going to hold it to be invalid is the court it's pending before, which is the Brooklyn County Court. So until that happens, it's a valid period of tolling. If in the event that somehow in the future it is found to be invalid, a motion for resentencing, a 44020 can be made, but at this moment, that period of tolling is valid. There has been no determination that that conviction for attempted murder was invalid or that the resulting sentence was invalid. So I think that's a simple way. I know there's been a lot of back and forth in the record, but really distilled to it, it's just that the predicate that he did not challenge was first-degree robbery, and under Penal Law 7006, it's any period of incarceration for any reason, and any reason means it's still reasonable because it has not been invalidated.
Okay.
Counsel, did ineffective assistance of counsel for defense counsel not to insist at that time that the trial judge rule on the substance of the 44010 motion? In other words, sort of take it away from Brooklyn and look at the conviction. And should defense counsel have insisted on that? And, you know, is that ineffective assistance counsel that he did not?
I don't believe that this court has jurisdiction to determine the validity of a Kings County conviction. And again, he's not challenging the predicate. I mean, I see under, you know, the CPL for 421, if you challenge the actual predicate, maybe that's something that the sentencing court here can do, but he did not challenge the predicate. It's the first-degree robbery that's the predicate.
Okay.
And we don't have jurisdiction to determine the validity of a Kings County conviction.
Okay.
Unless, oh, Your Honor, I just, there were other issues raised in the reply brief, and I understand that he has not raised them, so I'm not responding, but.
Well, we have your briefs. We have your briefs on those issues, and we've read those. So let me ask you something. I mean, this alleged 440 motion that's been pending for 12 years. I mean, how about like somebody, you know, checking out where that is in Kings County? I mean, you know, you can't just make a motion, then say, okay, we made a motion, now it's challenging. It's 12 years ago. What's the status of that?
Is this question for me, Your Honor?
Yes, yes.
I'm sorry.
Sorry.
Okay.
So a lot of this information is outside the existing appellate record. I can say that the record very clearly establishes that there was a pending 440 at the time of this trial, and my understanding is that that 440 still remains pending. Again, I can't speak to all the strategic reasons behind that, but I can note that Mr. Rodney is not a U.S. citizen, and so there perhaps might have been some strategic reason at the time for not pursuing that. But again, none of that information is in the record. What is in the record is that the trial lawyer in this case very clearly acknowledged that there were serious allegations of a faulty conviction.
Counsel, this is Judge Scarpula. Is there anything in this record that at the time of sentencing, that tolling was improper? There's at the time of sentencing, nothing, there was no decision saying that the conviction had been overturned or anything else, right?
Yes, so at
the time of sentencing, the trial judge is entitled to assume that the conviction hasn't been overturned, the period is there, and you can toll with it, right?
No, that's not right. So as to your first point, there has been no judicial order, and there was not overturning the homicide conviction. What had happened is that defense counsel had alleged, based on documents that remained pending in that case, that there were serious questions about that. Under the law, there does not have to be vacatur of that previous conviction. The court has an independent obligation to consider, find out what's going on in the status of that litigation. And also in many cases, the court will take its own independent look at the record to see whether it thinks that conviction is constitutional or not. But I want to be clear that that's beyond the scope of what we're arguing here. What we're arguing here is that once defense counsel presented what the trial court acknowledged were very serious allegations of a faulty conviction, it had to at least hold a hearing and decide this legal question. The respondent is presenting, these arguments that vacatur is required and not required. The trial court never actually decided this question. It's tried to step around that question, but that wasn't what the statute required. It was.
Are you saying that a judge in Manhattan can decide a motion that's pending in Brooklyn before some other judge?
No, I'm not saying that.
Then what are you saying? The motion is in front of a judge in Brooklyn, right?
So, yes, but in a sentencing court has an independent obligation to ensure that a sentence isn't enhanced based on an unconstitutional prior conviction.
So you mean they have to go behind the fact, they can't just say, okay, there's a motion pending, so there's a motion pending. They needed to go behind it and look at maybe the claims to see if they thought that there was some issue. Is that what you're suggesting?
So yes, and the Court of Appeals has held, in fact, that vacatur isn't a prerequisite to doing something like that. But again, I think that all that this court needs to say here is it doesn't have to hold that. It just has to say that once defense counsel presented these serious allegations, the sentencing court had to decide that in the first instance.
Okay, we will have your other arguments on the record. Thank you both very much. Appreciate it. Have a nice day. The next case for oral argument is Gendel versus 42 West 17th. Plaintiff, appellant, please. You may begin. Who is the plaintiff appellant? Mr. Metz? Uh-oh. Mr. Metz, are you around? I know who you are, but I don't see you.
Your Honor. Your Honor, before I start, I would just like to ask whether I should just address the appeal and the cross appeal all in one time, or would you like to break that up?
Well, each side, I gave 6 minutes to each side, so why don't you just address everything that you feel is most important to address, okay?
Absolutely, Your Honor. May it please the court, my name is Jeffrey Metz. I represent the appellant's cross respondents in this appeal. Your Honor, we believe that the court erred in not granting my client summary judgment with respect to the breach of contract cause of action. I think the court somewhat offhand remarked that there were a lot of factual issues when there was no argument with respect to the motions on that, sort of missed the point. The point here, I believe, Your Honors, is that if there may be dispute as to facts, but there's no dispute as to the liability here. You have a situation here where a co-op absolutely refused to deal with their obligations, both under the proprietary lease as well as under the law. We pointed out in our brief that the proprietary lease places roof and building envelope responsibilities in paragraph 2, in paragraph 7. It's referred to in paragraph 21A and also in paragraph 25. Moreover, Your Honors, in the offering plan, there are repeated references of the sponsor's obligation to take care of flashing, several obligations.
But Mr. Metz, weren't there, over the years of discovery, and this case has been going on, hasn't there been raised various issues of fact as to whose responsibility it was under the proprietary lease to do certain things? Because there were certain allegations by the co-op that some of the renovations that was done either by your clients or the previous owner were done in a not such a great way, sort of a shoddy workmanship, and those contributed to some extent to some of the problems that you're having now. And so exactly that we didn't dismiss, right, your breach of contract claim. They didn't dismiss it, but it's just you wouldn't granted summary judgment on it.
Sure. Well, Judge, let me respond to that. The co-op, and if you look at their brief, the only provision that they cite to in either the proprietary lease or the offering plan is the Second Amendment. The Second Amendment in paragraph 5 talks about the improvements that was made by Mr. Joseph, who was one of the original sponsors. Now, Your Honor, today I took a look at a case from your court that defined what an improvement was, but I got something I think that's close enough. And basically, it's a permanent addition or a betterment to real property that enhances capital value. That's what paragraph amendment 2 speaks to. It does not provide that Joseph or any subsequent user has to maintain, because it's the co-op's responsibility to maintain. Because if it was Joseph's responsibility, they could have drafted language in the proprietary lease to cover that. We cite to you at page 25 of our brief, Your Honor, this Morio against Turtle Bay case, where there was, in paragraph 18 of that particular proprietary lease, there was specifically drafted language saying that penthouse owners were responsible for maintaining roof and greenhouses on there. That's simply not the case here. And what you have here is you have a multitude of sources. Now, look, Judge, you've got this pressure tank roof. Both experts said there's a hole in there. Water is coming in from there. It's undisputed that water was coming in from the eastern facade that was defectively waterproof. That's got nothing to do with what Joseph did or did not do. You have, on the southern part, you have the roof drain that in 2013, they said, the co-op said they were going to replace, and 7 years later, they have yet to do so. Now, why is this? How can something like this happen? It happens because this is a small co-op. It's run by this woman, Ruth Miller. The testimony is clear. We cite to a chapter and verse. They don't want to increase the maintenance on the board members. This is a small co-op. That's why they don't have a sufficient reserve fund, and that's why they have continued to ignore my client's rights and obligations. Let's just go back. Let's go back to 96.
Well, isn't that why, I mean, at least partially why the judge allowed to stay in the negligence claim, because some of the actions on the part of the defendant go beyond the contractual obligations that they have?
Well, yes. Well, look, Judge, as far as that goes, for sure, there's no doubt about that. There is a non-delegable duty for the co-op here to maintain the building. There is a statutory scheme, and we cite to it in our brief. There are 4 or 5 regulations here, Judge. There's multiple dwelling law 78. There's several provisions of the administrative code saying, for example, that the presence of mold inside a unit is a violation, and we do know, and there's no dispute as to this, little kids are suffering from mold because of the water infestation that the board knew about, and they refused to take any action to address. Remember, Your Honor, back in 2015, my clients said to the board, let's do this. Let's split the cost of making the repairs, and we'll figure out who's responsible later. And the co-op turned them down flatly. And the board president, Mandel, said they did that because they did not have the money. Now, I don't know if they didn't have the money or they didn't want to spend the money, but as a result of what they did.
This is Judge Scarpullo. Isn't there evidence in the record that the water and all the mold and everything else comes from the skylight? And isn't the skylight your client's responsibility?
No, Your Honor, with respect, that's simply not the case. If you take a look at the offering plan, the lessor's duties include repairing roofing, flashing, gutters, leaders, painting, ceiling vents. There are, and again, Your Honor, there are a multitude of sources of where these water leaks are coming from. It's just not the flashing.
Well, isn't that sharply in dispute where it's coming from? I mean, I looked at expert reports saying completely different things. Well, and you want summary judgment?
Well, I can tell you what my adversary said. My adversary, the way that he counted it by basically saying that there's a disputed issue of fact of whether it was coming from the gravity water tank because no expert spoke to that. Well, that's a dodge, Your Honor. That's got nothing to do with the fact that there's no dispute that water was coming in from the pressure tank room. And by the way, Your Honor, you just go back to 1996 when Joseph said, I'm having leaks, I need the roof repaired. The co-op, knowing what their obligations were, repaired the roof at that time, and every piece except for where the water tower is. So now you have a piece of roof there that is 35 years old when the useful life is 10 to 15 years. Now that's not on my client. They have a non-delegable duty to maintain the roof, Your Honor.
Okay, let me just ask you this. The Second Amendment to the offering plan allows him to construct a third unit, right? He gets extra shares, and then that part becomes his.
Correct.
So there is quite a dispute, and the defendants are saying that's the problem, not our problem, your problem. And there are documents and there are expert testimonies going every which way.
Well,
so
Judge.
Again, I ask you, how could we possibly grant summary judgment in that?
Well, I have an answer for you there, Judge.
All right, you better hurry up because I've given you a lot of time.
I'm sorry, Your Honor. All you have to do is look back in 1996 when the co-op conferred with their counsel at that time and said it's our obligation to repair the roof. And when push came to shove in 2013 and 14, when they were called upon to make the repairs again, they didn't have the money, so they made up this thing with the Second Amendment, which is just not controlling here, because you can have an improvement, but the lease does not require them to maintain the improvement.
Okay,
Thank you.
Mr. Metz, I'll tell you what, I'll give you 1 minute for rebuttal. I'd like to hear from Mr. Fisher now, okay?
Thank you, Your Honor.
You're welcome.
Sorry, thank you, Your Honor. I appreciate it. I would like to address, first of all, a couple of the statements counsel made in his argument. The claim that there's no dispute that water is coming through the pressure tank room floor, that is simply inaccurate. The plaintiff's expert identified 3 locations of water infiltration, which they believe to be the skylights, the bulkheads, and the air conditioning penetrations for the air conditioning units that are solely for the 12th floor's use. These structures were all the structures that were constructed by Mr. Joseph per the Second Amendment to the offering plan. The other structures, the expert indicated there might be water coming through. Our expert disputes those claims. So at the very least, that alone justifies the denial and requires the denial of the motion for summary judgment. So that claim I believe is clearly not necessary to grant summary judgment. I would also argue, as to the plaintiff's motion for summary judgment, these units were all constructed by Mr. Joseph. He's the sponsor, he's a board member, all of these things. And counsel referenced that we should have put language in the Second Amendment as to who was maintaining these structures. We were not a party to that Second Amendment to the offering plan. That was done by Mr. Joseph wearing multiple hats prior to the formation of the board, or certainly of the independent board, on behalf of the co-op.
Because he bought it before it turned into before it converted into a co-op, right?
Correct. He bought it, and then he's the person who converted it, and as part of that, he got the 12th floor units. Right. So he was wearing the hat of unit owners on the 12th floor, sponsor of the building, and he was also a board member at that time, or what would be the forerunner to the board. It's not an independent entity at that point. So clearly, there's a significant question as to what interest Mr. Joseph was representing at the time of the Second Amendment. And plaintiff seeks to have it construed against the co-op, who's not a party to the agreement, is clearly improper. I'd also like to touch upon, for our motion, Your Honor, the plaintiff cannot bring the concurrent claims for breach of contract and negligence. They would have to show catastrophic consequences, and the case law is pretty clear about this. They have to show catastrophic consequences or a significant public interest that's going to be justified.
Well, I don't know if there's a difference between negligence and gross negligence. The court did dismiss the gross negligence claims, left the negligence in, but really, there are years that the plaintiffs are living here, living in these apartments, and sometimes not even able to live in the apartment, I think, and they're suffering the consequences of mold. They have children. There's a lot of consequences here. So why would the court, what is the problem under these circumstances of at least keeping in a negligence claim above and beyond just the strict breach of contract claim?
Because, Your Honor, what's catastrophic consequences is generally defined as something that, a building facade collapse. or something like that, a sprinkler pipe bursting that can cause damage to multiple units, multiple individuals, can cause, maybe risk death.
This is causing infiltration of water and creating all kinds of problems in multiple units on the 12th floor. I mean, it's,
Correct, Your Honor, but those are all owned by the Gendels. The instances cited by plaintiff are instances where an entire building may be flooded or something of that nature. That is what's defined as catastrophic, and you can see that from the Baker versus 16 Sutton Place apartment case.
I'm very familiar with it. I wrote it down to, I had that case for years downtown.
I believe you did, Your Honor.
I
believe it's still existing.
Well, counsel, this is Judge Scarpula. If the problem is the roof, then there's a negligence claim, right? We don't know if the problem is the skyline or the roof, but if the problem is the roof, that's your responsibility under the multiple dwelling law, and that's a separate negligence claim from the breach of contract claim. So I don't know how we could possibly dismiss that.
Because, Your Honor, I would say that the breach of contract that the plaintiff is alleging is essentially that you failed to maintain the roof or whatever structures they believe are our responsibilities. So my position.
But you have a statutory duty, regardless of whatever your duty is under the proprietary lease. You have a statutory duty as the owner to maintain the roof, and if you're negligent in that, that's a separate cause of action. And we've said that ourselves. The First Department has said that ourselves more than one time. So I don't know how we could dismiss the regular negligence claim when, if it turns out that it is actually just the roof and not the skylight, that it's your responsibility, both under the proprietary lease and you have a separate duty under the multiple dwelling law.
Because,
right?
Your Honor, they haven't alleged that the roof itself is leaking. They are conflating essentially that the roof is the structures that are constructed upon the roof. They are not indicating that the roof, and they don't have any expert testimony to indicate that the roof is leaking. Their expert report indicates that the only other sources of leaks, other than these air conditioning penetrations, the bulkheads, the skylights, there's a possible infiltration on the east facade, which would not explain both units. And second of all, that this pressure tank room is leaking. But the pressure tank room, there's no that they make it as a possibility. There is no evidence that water is infiltrated not only through that location, but even water infiltrated into these.
How can we decide that on summary judgment? I'm sorry, Judge.
No, go ahead.
How can we possibly decide that on summary judgment? And I mean, the expert reports to me look like they said there was facade, which is also covered under the multiple dwelling law, and the pressure tank and parts of the roof. Are you saying that that's not true?
What I'm saying, Your Honor, is that the statement for the pressure tank room is that it could provide an avenue for water. That the statement about the east facade is that it required further study. So as to the source of it. So my position is, in the absence of showing that there's an issue with the roof, I don't believe that they have met their burden to maintain that action. And I would also argue that they're not entitled to maintain it in the first place because it's duplicative. And I don't believe that they've shown an independent statutory construction, or that they've shown that there's a catastrophic consequence here, as defined in the cases that we've cited in our brief.
Okay. Can I, Mr. Metz, I'm going to give you 1 minute.
Sure. Thank you.
But thank you, Mr. Fisher. Appreciate it. Okay, just 1 minute. That's it.
Sure. No, thank you, Your Honor. All I would ask you to do is take a look at the Second Amendment again, and vis-a-vis what constitutes an improvement. If the court finds that an improvement also carries with it the responsibility to maintain the improvement, even though there's no language in there that says that, then there's a disputed issue of fact. I believe if you find otherwise, then we are entitled to summary judgment. And I thank you very much for your time today, Your Honors.
Okay, counsel, I thank you both very much. We will take another look in your briefs. Thank you. The next case for argument is WDF versus Harleysville.
Yes, good afternoon.
Good afternoon.
May it please the court, my name is Sophia Uveda for Appellant WDF. This case involves a coverage dispute in which WDF is seeking the benefit of the bargain in the form of defense costs, indemnity for a personal injury settlement, and a declaration that defendant Harleysville's policy is primary to all other available insurance. To address a preliminary procedural point, the Supreme Court incorrectly found that the additional insured coverage issue was already decided. The underlying Mulvana action decided contractual indemnity under the VAMCO construction contract, not additional insured coverage under the Harleysville's policy. So this issue is ripe for adjudication in this declaratory judgment. On the merits, if you don't mind, I will address the duty to defend first because it is significantly broader. In a case where the personal injury plaintiff is the insured's employee injured in the scope of employment and alleging that the negligence was in the work conditions or practices, there is clearly reasonable possibility of coverage triggering duty to defend. Specifically, Mulvana alleged in the amended complaint that both of his accidents were caused as a result of unsafe, hazardous, dangerous, and/or defective worksite and practices. The insured VAMCO was the only entity that controlled plaintiff's practices. Furthermore, the third-party complaint by the construction manager Turner alleges that if it's held liable in the Mulvana action, that liability will have been caused by VAMCO's negligence, carelessness, recklessness, and/or breach of contract. Given the broad duty to defend and these allegations in the pleadings, Harleyville, it's our position, breached its contract on the duty to defend in 2012 when it declined to take the defense, and WDF is at this point entitled to the defense costs it has exerted. Turning to the indemnity issue, since the Mulvana action settled before trial, we have no determination of negligence or proximate cause. The Burlington decision that both parties cite requires a showing of proximate causation for indemnity. It does not require a showing that VAMCO was not negligent, contrary to Harleyville's earlier position. And we, in moving for summary judgment, submitted the deposition transcripts and the evidence that make that proximate cause showing. Mr. Mulvana, in the first accident, claims that he tripped over an electrical conduit. He claims that there were about 15 to 20 conduits on that floor. Mr. Mulvana's supervisor, VAMCO's foreman, admitted during his deposition that he knew of prior complaints by various employees that these conduits were tripping hazards. And he still directed Mr. Mulvana to work on that floor and in that area. And given that it's black letter law that you can have more than one proximate cause and the evidence that VAMCO directed Mr. Mulvana to work near tripping hazards, our position is that that establishes the proximate cause necessary to establish additional insured coverage. And that's just the first accident. The same thing for the second accident. The second accident, about a week later, Mr. Mulvana tripped over an angle iron on the same floor. He testifies that the angle iron was loose debris and that he had previously complained to his supervisor about loose debris on that floor. The deposition testimony for the supervisor, VAMCO supervisor, was that yes, the iron was there, but it was essential to the work because it was holding up a safety net protecting the staircase. But in either testimony, VAMCO is admittedly on notice of a plainly visible tripping hazard and is still directing their workers to work in the area.
So you're saying this is any incident that was caused in whole or in part by an act or admission of VAMCO. So that's the proximate cause issue. So that, based on the testimony, obviously we're never going to have a trial because the case settled. But there are at least a proximate cause of both of these accidents, and therefore you're entitled to indemnification.
VAMCO was at least a proximate cause of at least one of these accidents, if not both of these accidents, which would have established our summary judgment standard. Now, again, there's never going to be a trial in the Mulvaney action. Our alternate relief below was that, you know, even if you don't grant our summary judgment, we're still entitled to a hearing in the DJ. But that's only if the court doesn't find that we've met our burden on summary judgment.
Okay. I think we have your argument. Does anyone have any questions? Okay. You have 2 minutes for rebuttal. May I hear from Harleyville's counsel, please?
Good afternoon, Your Honor. May it please the court. I would like to first address the issue that counsel just addressed, which is the theory that there was proximate cause and therefore the Harleysville additional insured policy applies. Even though she has referred to the standard proximate cause, it sounds that the standard that they're using is the sort of the arising out of standard that's discussed in the Burlington case. In Burlington, the court made a clear distinction of you may have a case where you either have you're a cause but not a proximate cause sufficient to find liability on fault versus a but-for cause. WDF seems to be arguing that just by virtue of the fact that the plaintiff in Mulvaney was an employee of VAMCO and present at the site as an employee of VAMCO, that is sufficient to establish proximate cause. And that's not consistent.
I didn't think that's what she said. I mean, she went further than that, the way I understood it, and saying that the testimony of VAMCO's project manager and foreman suggested that VAMCO controlled all the work that Mr. Mulvaney was doing, told him where to go, what to do. He didn't go to anybody else to get his instructions and directions. And therefore, that by telling him to work where there were problems, where they knew there were problems, that was at least a proximate cause. So it wasn't just the fact that he was employed by VAMCO. I thought, you know, she went past that, which seems to be based on the testimony that at least I could read in the record.
That sounds pretty speculative. The testimony, and in fact, as cited in WDF's briefs, they keep referring to there's multiple versions of this, and in fact, they refer to a version of plaintiff was, you know, merely walking toward Mr. Fox, and that's how he fell. So they're speculating that there's this theory out there that by, you know, having the plaintiff work at the site, it was all of a sudden VAMCO was the proximate cause of the accident. In the underlying Mulvaney action, all of the proof and all the claims was that the accident was proximately caused by 5-star, but 5-star's equipment or installation of equipment. There was no claim in the underlying Mulvaney action that it was VAMCO's fault that proximately caused the plaintiff's injuries. And under Burlington, you have to have proximate cause. And in this record, there is none. So, you know, it is our position that Judge Chan's decision was entirely correct and inconsistent, you know, one with the Burlington decision, but also with Justice Graham's decision. You know, WDF is trying to circumvent the underlying decision by Justice Graham by trying to impose an obligation that does not exist. The Harleysville policy limits coverage to an additional insured where there is coverage, and in the language of the additional insured provision, coverage is where there is a contractual obligation acquired by VAMCO. VAMCO's obligation is limited to an injury arising out of use of tools and equipment of WDF. There is no claim in the underlying action that plaintiff's accidents occurred as a result of use or of tools or equipment of VAMCO. By virtue of that, the policy, the additional insured provisions of the Harleysville policy was never triggered. And that's why the Graham decision made that determination. And that's why Judge Chan's decision dismissed the claims here. WDF seems to be bypassing that whole analysis and moving straight into a causation analysis that's not supported by the record. The other
does the Supreme Court's decision make the distinction that you just made between the VAMCO contract and the Harleysville policy? It seemed to me that Supreme Court, in error, found that the indemnification provision contained in the Harleysville policy was found to be not triggered by the Movina court, and I don't think that's what happened.
The language of the decision, I guess, is just what your point perhaps is not as clear as making sort of the two distinctions. But if you read the decision in conjunction with both the Harleysville policy and the VAMCO subcontract, the Harleysville policy provides that the additional insured coverage is for whatever liability VAMCO assumes. VAMCO's assumption of liability is limited to liability that arises from the use of tools and equipment of WDF, which does not apply in this case because there is no claim that the accidents occurred as a result of tools and equipment. So to answer your question, it may not have been written as clearly as distinguishing the two, but if you read it in conjunction with the two policies, that's what the decision comes down to. And WDF here is trying to circumvent that determination by trying to find coverage where it does not exist. The additional insured policy endorsement was not triggered.
Okay, I think we get your point. Any other questions, judges? All right, Miss
Veda?
Okay, you have, sorry, I have a hard time. I'm sure I'm not the only one. You have 2 minutes for rebuttal. Thank you.
I just want to briefly address 2 points. The first one is kind of the last point about Judge Graham's decision. The insurance policy Harleysville provided is triggered in one of 2 ways. One, VAMCO is actually found liable for contractual indemnity to us, and as the insurer for VAMCO, it has to pay when VAMCO is found liable. Second is if we, WDF, are an additional insured. That's the confusion. Yes, if VAMCO was found liable for contractual indemnification because VAMCO breached the contractual indemnity agreement in the construction contract, Harleysville would have to pay. But we're also talking about the additional insured coverage. We weren't seeking contractual indemnification in this action. We're seeking additional insured coverage, and that is triggered whenever a claim arises caused in whole or in part by an act or omission of VAMCO.
Can I ask you a question? The other counsel and in their brief also, Harleysville relied very much on the fact that neither accident involved WDF's tools or equipment, and so therefore their policy can't end up covering, covering it, and therefore they do not owe you any kind of repayment. What are the tools and equipment of WDF have to do with this, and is she right?
No, respectfully, she's not. In the construction contract between WDF and VAMCO, we had a very limited contractual indemnity provision saying that VAMCO will be liable for contractual indemnity only if it uses our tools or equipment.
So that was the contractual indemnification.
Yes. And then VAMCO was also supposed to, under the contract, go out and purchase a policy which names us as an additional insured, which is what is actually the subject of this lawsuit, and which is why those 2 decisions the Supreme Court incorrectly conflated.
Okay.
I just want to briefly address the other point.
Yeah, you just have 1 minute, so just finish it up, okay?
I'll try to finish it up, which is that we're somehow arguing for but-for causation instead of proximate cause. Just going back to the basics of negligence in a construction site, you can be negligent one of 2 ways. You can control the means and methods of the work, or you can have, notice of a defective condition and fail to remedy it. We have shown, even though we technically don't have to show negligence, that VAMCO fit both parts. It controlled the means and methods of Mulvaina's work, and it had notice of these hazardous tripping conditions and failed to remedy them, instead sending their employees to work in a site with tripping hazards. So we're not showing but-for causation like there's Burlington, where they had their employee working and they didn't know that there was something, explosive where the employee was digging. We're saying they knew where they were sending them was dangerous, and that's how it's different.
Okay, any further questions? Okay, thank you both very much for the arguments. We'll look at your briefs again.
Thank you, Your Honor.
Okay, now, see, I was right on target. You'd have 2 hours to talk to each other, almost on the nose. You had 2 hours to talk to each other. So ZDG you said you'll take 5 minutes. Did the defendants sort of figure out something to do when I get to you guys, the respondents?
Yes, Your Honor. This is Sophia Cahill on behalf of respondent ZDG.
Yeah.
I will take 3 minutes at this point, and co-respondent counsel for Gary Lebovitsky is requesting a minute and a half to 2 minutes to address 2 issues pertinent to his client. And counsel for TSC has not requested any time. As the court mentioned earlier, our issues are aligned.
Okay, thank you. I appreciate you all doing that. So stay on the line and listen to each other, and thank you for your courtesies. Okay, so let me hear from defendant 310 group. You're the appellant, so we get to hear from you for 5 minutes. Okay.
Good afternoon. Michael Strauss of Hollander Law Group for appellant 310 group.
Okay.
Now, I understand the court has read the briefs, and there's just a simple point that I want to make here, and that is that the imposition of the harshest penalty possible for 310 group's delayed discovery responses is inappropriate here. This court has characterized that kind of sanction as the most drastic remedy.
Counsel, would you concede that there was serial noncompliance with discovery orders?
I would concede that there was noncompliance with approximately 4 of the orders.
Went on for a while. So what's a court supposed to do in that situation?
Well, I don't know the answer, Your Honor, but I would say that dismissal of counterclaims and a third-party complaint involving millions of dollars is not the appropriate remedy.
What about the point that also, in addition to the main defendants not getting their discovery, that even 2 weeks after the initial sua sponte order, there was no response to some of the third-party defendants' requests for discovery? Isn't that flagrant?
No, Your Honor. We continued to work on the discovery responses. As of the issuance of the first order, we had responded to the majority, more than the majority, of the outstanding discovery requests, and we continue to do so. There was one party, I don't recall the name exactly, who quote unquote rejected our discovery responses, but we continue to provide them even after the order. And it wasn't a situation where the order was issued and we said, okay, now we're going to respond. We continued to respond prior to the order.
All right.
Well, never mind.
Judge Mendez, please, do you have a question?
That's fine.
Okay. All right. Well, if no one has a question, we'll let you reserve your time for rebuttal, and let's hear what some of the respondents have to say. So, Ms. Cahill, thank you very much.
Yes,
you represent the plaintiff in this case, correct?
Yes, plaintiff respondent ZDG LLC.
Okay.
May it please the court, as I noted, my name is Sophia Cahill from the law firm of Shepard, Mullen, Richter, and Hampton, appearing today on behalf of plaintiff respondent ZDG. It's our position, along with the co-respondents, that the lower court did not abuse its discretion in issuing the August 19th, 2019 order and subsequent January 21st, 2020 orders. And simply put, this case really comes down to one thing: the credibility and enforcement of court orders. Appellant maintains in the papers, as I know the court has read, that because the conduct was not willful and contumacious, the order must be vacated. However, such conduct can be inferred from repeated noncompliance with discovery orders issued by the court. And that's precisely what we have here. There's a May 2018 order. Appellant did not comply. And October 10th.
We know the schedule. But
Yeah.
Talk about prejudice. I mean, this is a heavy penalty. So what was the prejudice to your clients in the delay? Because there was piecemeal compliance, or as the 310 puts it, substantial compliance.
Respectfully, Your Honor, it's not our position that the burden shifts to us to demonstrate prejudice. However, there is extreme prejudice here. We filed the complaint initially in 2016, an amended complaint in late 2017. Discovery didn't kick off until June 2018, and here we are, April 2021. We're still waiting. There's a significant lien on the claim. That's our, the bulk of our claim, as well as other termination of wrongful termination of construction contract, and we're still waiting. So solely due to the non-compliance of appellant are we left without a remedy, quite frankly, and that's the significant prejudice here, Your Honor.
If there are no further questions, we'll hear from Mr. Is that Mr. Blutman or Mr. Glaus? Mr. Blutman?
Yeah, Mr. Blutman from Costello, Shea and Gaffney.
Yes.
Yes, good afternoon, Your Honors, and may it please the court. We represent third-party defendant Gary Lebovatsky in this case. Mr. Lebovatsky is an owner of a crane company, and he has no insurance in this matter. He was brought into the action and appeared in February of 2019. I'm not going to go over all of the orders because I know everyone is familiar with it, and I said I would limit my time. But what is somewhat different concerning my client is that when Judge Kennedy issued the order that she did on August 9th of 2019, my client received absolutely nothing in the form of discovery. No compliance with the February order from Counsel for 310 Group, no compliance with the May 2019 order from Counsel for 310 Group, even though the May order specifically said if there is no compliance, the answer will be stricken, the third-party complaint will be dismissed. The only other point that I wish to make, because I did say I would limit my time, is that I was in attendance at the July 10th conference before Judge Kennedy. At no time during that conference did the court order an extension of time for the defendant third-party plaintiff to provide discovery for 2 additional weeks. And at no point did the parties enter into any stipulation. And as the
court never issued an order for after that conference, is that correct?
That is after that conference, the order that was issued was the August 9th order of Judge Kennedy.
Right, the one that dismissed it. That was the first one.
That's correct. That is correct. And also, as the record on appeal would indicate, with the transcript of December 18th of 2019, when all parties appeared for the motion to renew and re-argue,
right.
Judge Kennedy unequivocally asked Counsel for 310 Group whether he had any reasonable excuse for not complying, and the answer was no. Judge Kennedy also unequivocally asked Counsel for 310 Group, were you given an extension of time during the July 10th, 2019 conference? The answer was no on the record. And when he was asked, was a stipulation entered into by the parties to extend your time for discovery? The answer, once again, was no. Thank you.
Thank you. All right, Mr. Strauss, you can have a few minutes, 2 minutes to respond to what counsel said. You're muted, Mr. Strauss.
Thank you. Ms. Cahill pointed out that discovery essentially incepted on June 20th, 2018, and the court's order striking 310 Group's pleadings was issued less than a year later. We're talking about a litigation that involves multiple parties.
So counsel, this is Judge Scarpula. If it's $1 million litigation, millions of dollar litigation, and there's a clear order that says you have to do this or your answer will be stricken, why didn't you comply?
We tried, Your Honor.
What do you, I don't understand, what does that mean? That's sort of like the check is in the mail and the dog ate my homework. What does that mean, we tried?
I respectfully.
Did you give out a single did you give any documents before July 10th?
Yes. I believe we did. But I mean, Mr. Blutman is correct in that there was no order, no stipulation at the May conference, but the application was made.
Well, why would you need more time if you comply?
I'm not sure I followed the question, Your Honor.
You just told me you did comply.
No, we didn't fully comply.
What was the story?
No, I don't want to mislead the court. We did not fully comply, but I believe there were responses. Some responses were served prior to that deadline.
I mean, it seems
you knew that, I'm sorry, even though you knew that your answer would be stricken, I mean, there's nothing unclear about that. Why not just comply?
Or at least make a motion explaining why you might not, for additional time for a certain type of discovery, because that's problematical. I mean, I understand discovery involves lots of documents. It's a big case. There's lots of parties. We understand that. We've all had cases like that. But, when the judge issues a conditional order, you have to assume that it means what it says. Once upon a time, maybe people didn't, but I think culture is changing. So that's, you can't just ignore those. I mean, I think that's the concern.
Well, the May conference was conducted before Judge Kennedy's law secretary. And again, the application was made at the conference.
Okay, well, we'll take another look at the documents. Thank you, and thank you all for your cooperation in moving the case along. I think we've gotten your points without having to hear them 3 times, so much appreciated.
Thank you.
Have a nice rest of the afternoon.
Thank you.
The next case for oral argument is Soa versus Zabar in New York City Elite Gym. Plaintiff Soa, you ready?
Yes, Your Honor, I'm ready. My name is Susan Polovich-Keaton, and I represent the plaintiff appellant Katarzyna Soa in this case. As I know that the briefs have been well studied, and I'd just like to focus on 2 main issues that I feel like really get to the heart of this appeal. The first issue that I'd like to address is whether the plaintiff established the cause of her fall. And the second issue that I'd like to address is whether the expert opinion on the deviation from industry standards was sufficiently corroborated. So with respect to the first issue, whether the plaintiff established the cause of her accident, there are 3 main categories of evidence that were submitted in terms of supporting how she fell and the manner in which she fell. The first category of evidence that was submitted was a detailed description of the physical location. There's a lot going on in terms of how this configuration of the storage closet was set up. So there was a lot of testimony describing the stairs, the locking door at the top of the stairs, the outswinging door, the small storage closet, and all of that configuration. There's also photographs submitted on the record that really detail the configuration. And
but
finally,
counsel, some aspects of that configuration really don't matter, correct? I mean, the door, for example, she said she fell while she was coming out of the closet. It didn't mention anything about holding onto the door or finding the door to be confusing or anything like that. What she did say at her EBT was about 4 or 5 different ways of saying she didn't know how she fell.
yes, Your Honor. And so in terms of the actually mechanics of the fall, she testified on 2 occasions, and both times she testified that the whole configuration was dangerous. And she explained exactly how she had to navigate in order to get in and out of the closet.
But I think what Justice Moulton is probably saying, and correct me if I'm wrong, Justice Moulton, but all of that may be true, but what actually caused her fall that day? I mean, I looked at all the pictures and I read about, you know, you might have to move it and the whole issue might not be as great as she would have liked. But what caused her to fall? Was that the stairs were wet? Was it that, you know, what was it? Was there something on the stairs? We couldn't be clear. I couldn't be clear looking at her testimony as to what caused her to fall. Given all the situations, what was it that caused her to fall?
Well, you know, Your Honors, just to go more, perhaps more directly to your point, the case of Broderick versus Edgewater is very similar to this, where the plaintiff was able to describe exactly what was happening immediately preceding the fall and immediately subsequent to the fall. What we've got here,
where the gentleman unfortunately fell over the parapet at his building, correct?
Yes, that's it. That's the
Somebody
case.
else had fallen over that parapet at the building previously, correct?
Right, there was. And there was expert testimony describing exactly what the measurements were of the parapet wall, what the deviations, what the industry standards should have been. And this case is very similar to that. A review of the testimony shows that she was in the closet, right? She had gotten the paper towels down. Right. And she was holding the paper towel. She had kind of turned around in the storage closet and she was making her way down the stairs. She testified that she was in the process of descending the stairs, right? And the next thing that she remembers, she was on the floor. And she described that her head hit the floor and how her body was positioned in terms of her lower extremities going off to the side. So it's very similar to the parapet wall case. But in terms of the respondent's characterization of the testimony, if you go back and kind of read the several pages before that, it's really detailed in terms of they're looking for how she was stepping, where she was stepping. And so this is an issue of whether she was on the third floor.
Didn't she say straight out more than one time, not just once, but several times, I do not know how I fell. I do not know what I fell from. I do not know what happened. I mean, that is pretty clear. If you look at her testimony, she doesn't just say it once, she says it 3 or 4 times. I know that I fell and I don't know how. I don't know how I fell. So that testimony, that she's the one. And you can point to 100 million things outside of that, but if she has no idea how she fell, it's just too speculative to say, or is there a reason why we shouldn't find that? Her statement, she has no idea how she fell to be, I mean, should we assume that's true?
Well, respectfully, Your Honor, as I'm looking at the record page, 903 to 904 and even somewhat into 905, she discusses what's the last thing that you remember before you found yourself on the floor of the bathroom. She says, I don't understand. You told me you were in the closet standing on the small tiled floor and that you got the paper towel, you turned around and you don't remember what happened, but you wound up on the floor in the bathroom. Is that correct? And she testifies, I was coming down. I had to come down with that paper because that was the reason I went there. I don't know how I fell. I just know that I fell off the steps and found myself on the floor. So again, we're talking about like a split section that she can't testify what happened from the process of her descending and her fall. And so she says, the question was, do you know what step or steps you fell off of? And she responds, I don't know exactly. I don't know exactly. Okay, and so this is what I'm talking about.
Okay, can you for 1 minute just address the expert because you've already gone sort of over your time?
Absolutely, I'll move along, Your Honor. And so in terms of the industry standards and what the court is looking at here, and this was set forth in the Court of Appeals in the Buchholz case, that they're looking for corroboration of the expert testimony. Where there is no code violation, where there is no applicable statute that's on point that can be shown to be violated, they want to have, the court wants to have some kind of corroboration with respect to the opinion of the industry standard. So this way, this can be referred to the jury and the jury can make a reasonable inference. In this particular case, there's two levels of corroboration, right? And if we look real quick at the Buchholz versus Trump case, which is the Court of Appeals case that really talks about what can qualify, what kind of evidence can qualify as corroborating, and it says, either an authority, a treatise, a standard, a building code, an article, or other corroborating evidence. In this case, you've got two levels. You've got the level of the Zorinsky architect saying, hey, you want to put a storage closet here? That's fine, but we need to break up this wall. We need to make it safer and move the stairs. We need to get rid of the stairs and break up the doorway, and then move the doorway to the other side, right? And this is shown in the plan work application, and it's shown in the temporary certificate of occupancy. And this was completely deviated from, and this is in the record. So that's one level of corroboration. The second level of corroboration it's more aligned with the Hybe case, right? Where the Hybe case requires that the expert really do some objective measurements. They want to see, what are the measurements of the location so we can really determine whether there's a deviation. And that was done in this case, which is detailed in the expert affidavit. And the second thing is that the second premise of the Hybe case is that later building codes may be consulted for specificity in terms of setting forth industry standards, because the codes and the industry standards do play off each other. But the qualification, and this was discussed in the Verdesi case versus 3225, that when the construction or when the renovation was done, that particular building code needs to be present and in effect at the time that industry standard may be alleged to have been followed. And
okay, I'll tell you what, I'll give you 2 minutes. I mean, you have 2 minutes on rebuttal. I've given you way over your time. I'd like to hear from the defendants, but as I said, I thought New York City Elite had made most of the arguments, and the other, the Zabar defendants kind of piggybacked on it. So who wants to make the argument?
Your Honor, Brendan Fitzpatrick for NYC Elite. I'll be making the arguments, and Mr. Weinberg is going to follow up with just, he said, a minute or two of just items that are specifically for his clients.
Okay, so you have 3 minutes. Go ahead.
Thank you, Your Honor. May it please the court, Brendan Fitzpatrick, counsel for NYC Elite. Your Honors, with respect to the first issue, I think Your Honors have essentially covered my points, is that plaintiff testified repeatedly to questions asking her to identify how she fell, identify what caused her to fall, and she repeatedly testified, I don't know. Even with respect to a question as simple as, can you tell us if you slipped, tripped, or something else, she replied, I don't know.
But counsel, that's not the end of the story, though. You would concede that. I mean, because this court, the First Department, has decided a number of cases where somebody falls and says something along those lines, and then there are other, types of evidence that can augment the plaintiff's claim and allow the plaintiff to survive summary judgment. Like in the Hybe case, for example, which is cited by your opponent, there's bad lighting, but the person who fell down the stairs, I believe, died in that case, and so of course wasn't able to testify. So in other words, you concede that just saying I don't know, the plaintiff saying I don't know, is not the end of the story.
No, you're right, it isn't. But here, that's all we have. In the Hybe case, I believe there was also video.
There was.
That was eventually destroyed, and I think there was an adverse inference charge.
Correct.
But I think when you have here, this isn't a situation where the plaintiff repeatedly testified, I don't remember. But then when shown a picture, said, yes, that's either if it's a broken roadway, and said, I don't remember where I fell, but yes, I was in that area when I fell. Something like that is a different story. And I think, Justice Moulton, that's definitely a situation where I know the First Department has repeatedly said, simply because you don't know isn't the be-all, end-all when you have other evidence. But here we don't have other evidence. What we have is plaintiff being asked repeatedly to let us know how the accident happened, and she didn't know. So even though she's claiming that, yes, it's dangerous, she failed to provide any evidence connecting some purported defect or condition with these steps with her fall on the date of the accident. And that's really the controlling factors here. Without that, a jury is going to be forced to speculate as to the issue of causation. And whereas it just could have been as easily as a misstep or a loss of balance that caused her to fall. And this court, as well as all of the other departments in the state, have repeatedly ruled when a plaintiff does not know the cause of their fall, and there's no other corroborating evidence to support it, and there's no connection, then dismissal is warranted. And I think the Supreme Court in this case correctly looked at all of the evidence and found that really that is what is lacking here. There is no connection to anything with respect to the steps, with respect to how she fell that day. Again, this is a situation where plaintiff had gone up and down these steps thousands of times over the years without any incident. Almost upwards of 10 times a day for 4 years, 6 days a week. Never a prior incident, never an accident. I think when you look at all of the testimony and indeed all of the evidence, it supports the dismissal of the complaint because plaintiff failed to identify the cause of her fall. With respect to the second issue that counsel addressed, their expert's affidavit, I think it's key that one of the main things that Mr. Ubell relied upon was plaintiff's affidavit. Now, there's no debate that plaintiff's affidavit was correctly rejected as inadmissible on 2 grounds. There was no affidavit attesting that this was read to her, that it was translated to her. She testified with the help of a translator on both occasions. Under Peralta Santos from this court and CPLR 2101B, that renders it inadmissible. In addition, she contradicted her prior testimony where she said she could then recall how her accident happened. But in addition, we have Mr. Scott, who submitted an affidavit where he went through each and every code, regulation, anything that plaintiff had cited to, anything that Mr. Ubell had cited to, and found that they weren't applicable. And one of the main ones was the presence of a handrail. Right. And according to the 1968 building code, it's not required here. So I think the Supreme Court had it right on both counts. And
was there any dispute that was there any dispute that it was the 1968 building code that controls in this situation?
I don't believe that there was any evidence once Mr. Scott put that evidence in and basically attested that, listen, that's what's controlling here. I don't think there was any debate about it, that it was controlling here. So,
okay, well, you kind of took up both your times, but Mr. Weinberg, yes, I'll give you a minute or so if you have anything to add that Mr. Fitzpatrick hasn't said.
Sorry about
Thank you, Your Honor. Just very briefly, in the event the court does not accept Mr. Fitzpatrick's arguments, which we obviously would adopt as our own, I would just point out that defendants Eli Zabar, Sandra Zabar, and Eats have no ownership interest or control of this building, and for that reason alone, they should be dismissed in the event the court finds that there are other questions of fact as to other defendants. So if the court has no other questions, we'll rest on our brief and Mr. Fitzpatrick's arguments.
Thank you for your courtesy, Mr. Weinberg.
Thanks.
Okay, Ms. Keaton, you have 2 minutes to respond to anything that they've said.
Thank you, Your Honors. I'll make this brief. Just to go to the last point first, with respect to Eli Zabar, he has signed off. He's been involved in this case. He signed off on the plan work application. He signed off on the lease agreement with NYC Elite. He directly was involved with many of these aspects. And Sandra and Devon also sued New York City Elite. So they're party plaintiffs in this case as trustees. With respect to EAT, Victor Sikora, who was an employee of Eli Zabar, he's involved in this case, and Robert Shaylock, who also signed off on the plan work application, was an employee, a direct employee of EATS, is owned by Eli Zabar. So there's a lot. It seems to me that the Zabar companies are very enmeshed, that there's a lot of crisscross, and we don't have a lot of clarity in terms of who was actually involved in all of that. But moving on, I just wanted to discuss the Verdes case very, very briefly, because the issue of the handrail came up and the affidavit as well. The Verdesi case, that the only defect alleged in that case was a lack of handrail, and we have an instance there where that stair, those two steps were there for literally decades and not changed. In this case, we've got, it wasn't just the steps that were issue. You know, the slip resistant was not an issue in our case. This is an issue of, you know, a whole configuration that made things very confusing, as we've stated before. In terms of the affidavit, Mr. Ubell was actually accompanied by the plaintiff when he did the inspection, and got the facts directly from her in terms of how she fell. There's actually a photograph of her pointing to where she fell and all of that. He did not rely on that affidavit exclusively to make his determination. And in terms of the, you know, the evidence that was submitted, I know there's a big issue on whether the affidavit was properly considered by the trial court. I would suggest that all of the evidence that I discussed in terms of where she was and her usual custom and practice of grabbing onto the door frame as she went down the stairs, this was all outside of the ambit of that affidavit that may or may not be thrown out. So even without the affidavit, there is enough for a jury to make a reasonable inference as to causation. And with that, I'll close. I thank you for your time.
Yes. All right. Thank you all very much. We'll take another look at the briefs and the record.
Thank you, Your Honor.
Have a good afternoon. Next case, if you're FIDA versus Department of Education. The appellant, please. Mr. Meyer, you're muted. Oh, you're still muted. Now you're okay. Okay, go ahead.
I represent appellant Lucio E. Orfida, a first-rank educator who was unlawfully terminated after 20 years of distinguished service with respondent DOE. The termination was procured by DOE's pervasive illegal conduct in violation of multiple mandatory statutes, which illegality was total and far beyond anything we found in any reported case before this or any other New York State court, rendering this matter unique like no other. The illegal conduct standing alone mandates vacatur of the unlawful termination, as our Court of Appeals held in Sequoia. In Sequoia, there was only violation of one mandatory statute. Here we have many more. The illegal conduct also rendered the purported hearing and unlawful termination void and without legal effect.
Counsel, didn't you have to waive the procedural alleged irregularities before the arbitrators? In other words, have you waived them?
The answer is that you can only waive something if you know about it. And the record is undisputed that Lucio had no knowledge regarding of what was going on. And nor does his lawyer have any idea of what.
Let's talk about what was going on. What are you talking about exactly? I thought you were talking about some procedural irregularities during the course of the hearing. What are you talking
about? Well, that, you know, my adversary refers to as simply a procedural irregularity, but it's not, Your Honor. It is, there are mandatory statutes requiring that there be impartial evaluations by evaluators and validators to ensure that there is an impartial factual record.
Didn't the arbitrator sort of wrestle with your argument that the evaluators were biased against him and the administrators were biased against him? And then reject those allegations? Didn't it at least confront them?
Respectfully, there's no mention of evaluators in the arbitrator's decision because the DOE refused to have any impartial evaluators evaluate.
Yeah, I meant the assistant principals and the principals did evaluate them.
I'm sorry. The only
There was nothing more than what the Scarmato group presented, which was directed towards getting him fired as soon as possible. The mandatory statutes require impartial evaluations by an independent evaluator. They also require independent evaluations by independent validators.
So,
Here,
Counsel, this is Judge Scarpula. Did you raise the impartiality of the and the statutes during the course of the arbitration?
Absolutely not, Your Honor, because as indicated in the record, and it's undisputed, that Lucio had no idea what was going on.
Is that an excuse for not raising something that you need to raise, but that I don't know?
Well, respectfully, Your Honor, the reason why was that the DOE, and it's undisputed in the record, the DOE was very secretive about what it was doing.
Did he have counsel?
Of course he had counsel.
So
yes,
he has counsel, and we assume that counsel knows what the DOE, what the relevant statutes are, and we assume that his counsel is competent to raise any procedural issues, and yet they weren't raised. Is that what you're saying?
I'm saying that you can't raise an issue if you don't know what's going on.
I don't know what that means, though. I guess that's my problem.
I'll be very clear on it, okay? The record is clear, undisputed, that Lucio had no knowledge regarding the DOE's illegal conduct.
No, but he has a lawyer, right?
Oh, no, wait a second. You need, exactly right. The lawyer had, there was no indication at that point that there was any illegal conduct. It was only after the receipt of the arbitrator's decision. And the bottom line is that you can't raise something if you don't know it. Understand, the DOE at the arbitration, if you look at the record, they submitted lots of material, and they also raised issues that were irrelevant. They tried to raise a different disciplinary matter. And so what happened was, it was very confusing. And the prior lawyer did not know, and if he doesn't know, he can't raise it.
Okay,
But that doesn't excuse.
Mr. Meyer, I've already given you more time. You have a couple of minutes for rebuttal, so let's hear from Ms. Carlin, and then we'll let you respond. Thank you so much. Ms. Carlin?
May it please the court, Antonella Carlin for the Department of Education. Just quickly, with respect to the waiver, this isn't something that occurred, like a factual issue that you don't find out about until after the fact. These are procedures that he's claiming DOE didn't follow during the school year that he says he's entitled to. And so he should know if DOE didn't fail to give him something that he was entitled to. He had a union lawyer and, excuse me, they didn't raise it. They didn't raise it at the arbitration. They didn't raise it with DOE. They didn't raise it with any of the school administrators. There's a reason for this, most likely because DOE did exactly what it was supposed to do here in evaluating him. He wasn't entitled to any of these things. But in any event, he has waived these arguments, and the penalty here is not shocking to the conscience, given the deficiencies that he showed repeatedly over the course of 2 years and his failure to remedy them despite significant remedial efforts made by the administrators. And if the court
wasn't this the case where the arbitrator issued a very lengthy opinion and award where he went through all the different issues? So he certainly was listening to all the testimony, the evidence, trying to evaluate everything before coming to the ultimate determination, correct?
Yes, and in fact, there were certain testimony, certain of the observation reports that the appellant disagreed with, and the arbitrator agreed with him in certain respects, but nonetheless found that overall the evidence supported the specifications, and ultimately that he should be terminated, because over the course of 2 years, if someone tells you repeatedly you need to improve this, and they provide you with resources to do it, and you don't want to, then at a certain point, DOE has to say, you can't teach for us anymore.
Okay, does anyone have any further questions for Ms. Carlin? All right, otherwise then we will, I assume you'll rest on your brief. Mr. Meyer, you have 2 minutes to respond.
I appreciate it. First of all, number one, counsel misstates the record. The claimed ineffective service was a 1-year period. It's in the record, undisputed, not 2 years, from March 2015 to March 2016. And so termination after 1 year.
But counsel, that was preceded by a year where he was found to be developing, right? Which for a teacher who started in 1996 or whenever it was, a while ago, that's kind of concerning. Would you concede that?
There was the prior year, it was only, March 2015 through March 2016. Before that, he was found to be wholly effective. Within 5 months after the Scarmato group took over, he was suddenly found ineffective. Now, also, there can be no claim of waiver because, as I indicated, there can be here the hearing and the unlawful termination was void because of failure to comply with the mandatory statutes. 2000, the 3012 C, 3012 D. They also can't, waiver doesn't apply if the underlying proceeding is void. And we argue that it's void because of the failure to comply with these mandatory statutes, which meant that there was no impartial record. Understand, Education Law 3020A requires an impartial hearing. An impartial hearing requires an impartial record. The mandatory statutes here are in place to ensure there's an impartial record. The DOE, by its illegal conduct, barred all impartial evaluations. By doing that, they made sure that there was no possibility of having an impartial record.
Okay, Mr. Meyer, I've given you a lot more time than we granted initially. So I think we got your point. We will we will look back at your.
I would ask, Your Honor, I would simply, the last question, just one final point, Your Honor.
One
point. One final point. But I don't quite understand. DOE indicates that, look at all they did for this man. But they don't talk about why they refused to conduct the impartial evaluations required by the multiple New York statutes. If the goal was to conduct it was to go have first-rate teachers, wouldn't you want an impartial evaluation rather than just what the Scarmato group put together to get rid of them?
Okay.
And secondly, if Lucio was as terrible as the Scarmato group claims, why were they unwilling to have him impartially evaluated as required by law? You can't just ignore the law.
We will certainly look back. Thank you both for your arguments and have a very good afternoon. Thank you for coming. Appreciate it. Next case, matter of people of the state of New York versus Orbital Publishing. Appellant Pugsley, you have 6 minutes.
Thank you, Your Honor. May it please the court. David Lennon of Lennon & Klein, attorney for Appellant Lydia Pugsley. There have been a series of errors in this case, which resulted in a $16 million judgment against Lydia Pugsley on summary judgment. In this case, twice the trial court ruled that there were issues of fact. The Attorney General appealed, and in that appeal, this court determined that a solicitation at issue in the case was deceptive as a matter of law. While we disagreed with that action, in that decision, the court in dicta stated that Ms. Pugsley may be liable.
Why do you say that's in dicta? I was on the court. I mean, I'm not sure that that's in, I mean, we write, you know, it was not a very long decision. I don't think that was in dicta. That's what we said.
No, I said
can be held individually liable. That's what we said.
No, I said, but based on the record, there were many issues of fact as to her liability. There was issues of fact as to her control. There was issues of fact.
But that's not what we said. But the thing is that, you know, we already decided 2 years ago what we decided 2 years ago, and that's, you know, law of the case. Yeah, I mean, I don't know if you tried to go to the Court of Appeals on this, but we wrote a unanimous decision, and we found that she was, you know, that she could be found individually liable, and talked about what the record demonstrated. We made these findings already.
I understand, Your Honor. In our opinion, it was unclear that you made a definitive determination. There was I was on the panel. I don't think it was unclear, so I guess I win on that one. But you know, I understand, Your Honor. I think the issue was that determination, there was never a record as to her personal liability. It was never adjudicated in the trial court, and because the trial court never got to that issue. I understand Your Honor's ruling, and it was, again, it was unclear to us, and I recognize that the trial court agreed with you that it was a definitive determination.
Right.
And you know, our appeal is that there was an inappropriate, or there wasn't a record to support a determination that she be held liable. And I understand that if we have an adverse ruling, that Ms. Pugsley's only recourse is to the Court of Appeals. But there's never been a case where a person in Ms. Pugsley's situation has been held liable under the executive law or the general business law, where she worked for a company that engaged in deceptive conduct and that she had nothing to do with those deceptions.
Well, I mean, there was evidence in the record that showed that she was involved in every aspect. She ran this business out of her home, I understood. She signed all kinds of documents. She was like the main person. She was one of the main people. I know there were two other people, but she was integrally involved in all of the different aspects of what this publishing group of people were doing, and that's, you know, that's what we saw. Now, I mean, it's a joint and several liability. I'm not sure what happened to all the other defendants in this case, but this is, you know, this is your appeal just for your one client.
Yes, Your Honor. All of the other defendants were corporations or other companies that were out of business. Ms. Pugsley was the only entity that was individually named, and it appears that there were issues of fact as to her liability, that there was no basis to definitively hold that she should be liable. She didn't control.
If assuming that we think that the first oral decision is law of the case, do you have any other arguments in opposition to the entry of the judgment?
Yes, Your Honor. One of the main arguments is that even if she could be held liable and an injunction would be appropriate, there's no basis to saddle her with a $16 million judgment. The evidence doesn't support that. The record doesn't support that. In fact, in the only other adjudication against Ms. Pugsley was after a 5-week trial in an FTC enforcement proceeding in Oregon, in which all of the participants were named. Mr. Simpson and Mr. Hoyle being the operative people who control this business. Ms. Pugsley was one of several other people who were identified simply as workers.
No, but counsel, let me ask you again. We assume that we think that the first orbital decision says she can be held liable, and we adhere to that. What other arguments do you have with respect to the amount of damages or anything else? That's what I'm trying to tell you.
Sure. Well, I think the first argument is that there should be no monetary relief awarded against her because of the nature of her role in this business. And, with all due respect to Justice Kapnick, the record doesn't support that she was involved in everything. I know the Attorney General argued that, but the record supported that she only answered to these two gentlemen, Simpson and Hoyle, and that they controlled the business. They received $30 million in profits. She received none of the profits. We don't deny that she was reasonably well paid. She earned approximately $200,000 a year, but Simpson and Hoyle were earning millions of dollars a year. In the 4 years prior to the demise of this business, they earned $30 million.
Well,
it just seems inequitable.
Judge Scarpula, isn't liability joint and several?
Except they're not named, and they're not named in this case. Okay. And we don't know why. We've been raising that issue since 2015, and the Attorney General refuses to give any information. They say it's in their discretion who they can sue, and that's fine, but they can't sue the assistant for the work of the principal. It's like suing a lawyer for not suing a lawyer for malpractice, it's like suing the paralegal for malpractice, not suing the lawyer. And the malpractice and the paralegal says, well, I just did what the lawyer told me. And this is no different. Miss Pugsley is a high school educated person that has been working for these gentlemen on and off for many years. And she had no reason to believe that this was be deemed deceptive. She didn't control anything. She simply provided bookkeeping services and data processing services. And all of her activities related to those two things. She didn't have anything to do with the solicitation. The Attorney General makes a big deal about the fact that over the many years that she was in the business, she disclosed that she made 2 suggestions regarding changes to the solicitation. Actually, she only made one was hers. One suggestion that was made was at the behest of the United States Postal Service that was communicated to Ms. Pugsley through their outside commercial printing company.
Okay, Mr. Lennon, I've given you a couple extra minutes. You have 2 for rebuttal. Let's hear from Ms. Olson, and then you can respond to anything she has to say. Ms. Olson, can we hear from you, please?
Thank you, Your Honor.
Thank you.
Good afternoon. May it please the court, Caroline Olson on behalf of the state. The court should affirm the judgment of Supreme Court, which held Ms. Pugsley individually liable for a sweeping fraud perpetrated on New York consumers and held her jointly and severally liable for the costs of that fraud. I plan to start with the Supreme Court's liability determination.
Are there any other individuals named in this case, or it's just the corporations?
It's just the corporations. As initially filed, Ms. Pugsley's sister, who she also brought into the scheme, had been named as a respondent. She was dismissed from the action for jurisdictional reasons, and so the only individual left is Ms. Pugsley.
What about the other two she was working for? What happened to them?
I'm sorry.
What about the 2, Mr. I don't recall their names. I'm sorry. I apologize. But the 2 men who were running the business that she was working for, why are they not defendants in this case?
What I can say is that at the time of the state's investigation, bear in mind that this operation was deluging New York consumers with somewhere between countrywide was sending out over 25 million of these mailers a year, and we needed to take rapid action. This was taken as an enforcement action to prevent the fraud. At the time that the state filed the action, the state happened to had the clearest evidence against Ms. Pugsley, and because of her central and important role in the action, it made sense to proceed see to get a stop to this abusive contract towards New York consumers. And the evidence also shows that this operation really could not have functioned absent her involvement. Whether you view this as a law of the case question or a de novo question of her liability, it is very clear that this operation turned on her involvement. As you mentioned,
what kind of sense does it make to have a $16 million judgment against this Miss Pugsley? I mean, what's? I mean, really, do you think Miss Pugsley has $16 million?
Well, a couple of points, Your Honors. The first is that it is a judgment against all the corporate respondents. I mean, that's
right.
That's the nature of
joint.
Joint.
They're not in bankruptcy, or they're still existing. These corporate. I mean, they're not even here today. Just Mr. Lennon is.
There's not much in the record as to the status of the corporate respondents. That is true, but they were held jointly and severally liable. They were respondents, and look, the state is not going to stand in Miss Pugsley's way if she seeks to contribution from these corporations or any of their corporate heads. She's still free to go after the individuals who she believes should be held liable, but all corporate respondents here were found liable, and as the testimony establishes, she played a very central role in this.
Did they default in this case? Did they default in this case, the corporate defendants?
No, not that I'm aware of, Your Honor. They just they did not choose to appeal the judgment. They did not choose to appeal the judgment below, but. Regardless, she has the action against them if she wants, but the nature of fraud and joint and several liability, which is if you participate in fraud and you're found jointly and severally liable, it is possible you can be held accountable for the full amount. And the judgment here is proportional and quite conservative relative to the harm caused by this operation, and there's no real challenge to the amount of harm to New York consumers or her central role. And again, this is someone who has admitted by her own testimony that she was involved in coming up with the language of the mailers. She received all cease and desist letters from publishers that objected to these mailers. She repeatedly ignored them after discussing the matter with counsel and making a decision. The operation operated out of her home in the face of evidence from banks and warnings from banks that the accounts for these corporate respondents had to close. She went ahead and opened up new bank accounts with different entities under different names, all of which, as the court in the FTC action found, were glaring signs of fraud that she just simply ignored. And given her central role in the operation and centrality to the scheme, indeed in her own testimony, she was involved in absolutely everything. It is appropriate that she, along with the other respondents, would be held liable for this judgment. A couple other points. I think Ms. Pugsley tries to turn this into a question of control, but that, for the purposes of liability, that is not the standard. That is not the standard of New York law. It's a question of knowledge.
Counsel, this is Judge Scarpullo. What about the fact that the Oregon court didn't hold her personally responsible? Why aren't we inconsistent? Isn't this inconsistent with the Oregon court, who actually had a trial on this issue?
A couple of points, Your Honor. The first is looking at that order, the court certainly found her liable for violations of the FTC Act, and in fact entered an injunction against her based on findings that she was both a central participant and had ignored had ignored the fraud and the misleading nature of these mailers. While the court chose not to award a financial award against her in that particular case, that was not a measure of the damage to New York consumers. It is not a constraint on this court. It is also true that was an award for different purposes. The FTC action did not involve mailers in connection to magazines. It only involved newspapers. It also involved a different profits as opposed to the cost to restitution and the cost that of fees that consumers paid. And so while it is true that the court in that case chose not to impose a penalty, that's no restriction on this court. And here, I think that is also not accurate as my colleague has mentioned, that there was sort of no record here with respect to Ms. Pugsley's liability. In Orbital 1, there were over 2,000 pages of documentary evidence in front of the court, including sworn testimony from Ms. Pugsley and affidavits from Ms. Pugsley testifying to her role and establishing undisputed facts that she has yet to dispute, that establish both her knowledge of the fraud and her status as a corporate officer. And I would also remind
Yes,
this court
if you can just finish up, because I've given you a little extra time already.
Of course, I would just point this court on my colleague's last point about her status as not a sort of not one of the, what he says is not one of the key players. Obviously, we'd disagree with that and would say that on many metrics, she was on par with Mr. Hoyle and Simpson. But under this court's, even most recently in the Northern leasing case that this court issued just a month ago, that held a non-owner jointly and severally liable for the fraud engaged in by the Northern leasing agents, in part because he was highly involved in the business in responding to consumer complaints and sort of involved in in many aspects of accounting, and he's a very similarly situated to Ms. Pugsley.
Thank you. Thank you very much, Ms. Olson. Mr. Lennon, you have 2 minutes.
Thank you, Your Honor. Just a couple of quick points.
Sure.
One is the record doesn't support that Ms. Pugsley was central. She was involved in bookkeeping just for the mail agents, and she was involved in managing data processing. There were many other people who were involved in other aspects of the business, and Simpson and Hoyle oversaw all the aspects of the business. As the district court in Oregon found.
Look, but I mean, the thing is, you know, I hear you, I feel your pain, but I mean, they chose, for whatever reason, I asked the question to Ms. Olson. She said they had a clearer case, an easier case against your client. I mean, it doesn't mean that they couldn't also, you know, they couldn't also have been defendants here, but they're not. The other defendants are also held jointly and severally liable. You don't represent them. I understand that. But, you know, I think the record does seem to reflect, to the extent I read it, that, you know, I mean, she's doing it out of her house. She was involved in every aspect. I didn't say she was the owner, but this isn't limited. The statute doesn't say just the owner. And if you work for the owner, no.
Your Honor, the part that she was only doing one small part out of her house. And there was a 5,000 square foot building where 50 people worked, which was not in her house.
What were they? They were just sending it? Okay, well.
They had scores of people working, a mail room, they had customer service people, bookkeepers. Miss Pugsley worked on one part out of her house. And then when the Attorney General started their investigation, she moved it out of her house. And you know, one of the points that we haven't addressed, but we address in our brief, is that she had no reason to know that this was fraudulent. There's never been a determination by anyone until these cases.
But I thought she had been getting letters from the some of the publishers that said, you know, cease and desist. You don't have our right to do this. I mean, that sort of would give you an idea that maybe what you're sending out is not exactly up and up.
So, Your Honor, she was not in charge of that. The businesses got cease and desist letters. And as the record supports, they were sent to her for a specific purpose, because Mr. Simpson and Mr. Hoyle made the determination that if the business had a way of clearing the orders through an entity other than the publisher, that they could. That there were scores of clearing firms that the businesses did business with. And it was not Miss Pugsley that made that determination. And one last point, Your Honor, as to Mr. Hoyle and the Attorney General's knowledge about Mr. Simpson and Mr. Hoyle, the attorney that prosecuted this case in January gave a seminar with a lobbyist for the publishers about this business. And they never named Miss Pugsley, but they named extensively Mr. Hoyle and Mr. Simpson. So it does not appear that that's correct what counsel said.
Okay, we will certainly look at the papers again. I thank you both for your time.
Your Honor, I lost you.
Oh, you lost me?
I don't hear you.
Oh, sorry. Okay, we're finished. Bye. Okay, next case, last case. So I told you I'd get to you in 3 hours. So I hope you had enough time to maybe settle the whole case.
Your Honor, you just came back. I didn't hear what you said.
I said, thank you very much. We'll look at the briefs. Have a nice afternoon. Goodbye.
Thank you, Your Honor.
Just waving.
Thank you.
Okay. Werner versus Credit Suisse.
Thank you, Your Honor. This is Kenneth Kelly representing Credit Suisse. I've spoken to Mr. Pegno, who represents Credit Suisse in the next case, and he'll limit his argument to the interest issue, which is not present in our case and is only present in his case.
Thank you. Okay, you got 5 minutes. Go ahead.
All right, thank you. Your Honor, there are no reported New York cases, either before or after the Court of Appeals decision in Trulove, which holds that compensation in the form of shares of the employer are wages under the New York labor law. Trulove held 21 years ago that if the value of compensation depends on exclusively or even in part on the financial success of the employer and is not dependent entirely on the employee's personal efforts, then it's not wages. It's as simple as that. In fact, even the court below, which affirmed the decision of the arbitrators and denied our request to vacate the liquidated damages award in this particular case, didn't try and distinguish that principle that stock is not wages. You have to understand in this case that nothing can be more dependent on the company's success than publicly traded shares, as are the shares of Credit Suisse here. But you have to understand how this works, and this is the key. The company grants compensation in the form of deferred shares. That means that the shares will vest over time, or they'll vest in an accelerated basis if the employee is terminated without cause. But in either case, the shares are delivered in accordance with the original vesting schedule, which could be 1 year, 2 years, or even in this particular case, with Mr. Lerner and Ms. Winterbaum, over 5 years. During those 5 years, the value of the shares fluctuates up and down, or could be nothing. The perfect example of could be nothing is the Lehman Brothers employees had deferred shares, and Lehman Brothers went bust, and that was the end of it. And the fact that the value of the shares fluctuates and it's beyond the control of the employee is the key to this case. This court in the Geary versus Goldman Sachs case held that what was dispositive in that case, which is identical here, in Geary, the employee worked for the investment bank. He received cash compensation, and part of the compensation was converted into shares that were going to be paid over time.
But counsel, you'd say you would concede that in Geary, the equity-based compensation had not yet vested in the plaintiff's there? That's a red herring, though. Is your argument, I believe.
Yeah, the argument, whether it's vesting or not vesting, is irrelevant. I mean, this court has held in the Gunfell case against Deutsche Bank, which was decided a couple of months after the decision in Geary, that vesting doesn't change the awards. The awards are based on factors outside of the work of the employee. The essence of the compensation, the deferred compensation, is equity shares. Whether it's vested, whether it's not vested, doesn't make any difference. The value still depends on the vagaries of the marketplace. In fact, Justice Scarpula in the Schoenbach case 2 or 3 years ago held exactly that in a case where the shares had vested, where this deferred compensation had vested within a week of the employee being terminated. And there she simply said, no, the essence doesn't change. So whether it's vested or not vested is irrelevant. And the fact that the court below relied on that as one of the attempts to find a fairly colorable explanation for the decision below is just simply wrong.
So, counsel, let me just clarify that you're only talking about the labor law claim here, right? You're not talking about, you're talking about whether this is wages under the labor law.
That's right.
Okay.
Yeah, we're not
on the same page with that. We're only talking about labor law.
Yeah, we're not.
You're saying no liquidated damages because it's not labor law.
That's right. Yeah, because that's a pure question of law. The compensation award was just based on issues of fact, and we're not appealing that. But the fact is, this court held that the manifest disregard principle still applies, and that was in the Credit Suisse against Finn case, which was decided last year. Here we have a principle that's well established. It's established to these facts because the facts here are identical to the facts in the Geary case. We called this to the attention of the arbitrators 4 times in our brief, in our reply brief, in our closing argument, and in demonstratives that put up in front of their face, just like the screen's in front of yours right now, quoting Geary and quoting Petrula. And they nevertheless disregarded that. And the reason why we say they disregarded it is they should have known better. Because as Mr. Lax is more than happy to point out on several occasions, the chairman of the panel was a professor of labor and employment law. This is not something that will go over the head of a lawyer who just happens to be sitting on the bench, on the arbitration panel. This was something that they should have known, and the fact that they should have known this and ignored it, and specifically went out of the way to make this a labor law claim in its award, saying it's a Section 198 response, shows that this was something that was known to them and should be thrown out. And second, if I may have one more moment.
That's all you can have, is one more moment.
One more moment. The fact that this is based on commissions is also irrelevant. The fact that commissions, yeah, sure, it's a fixed amount of shares that are awarded. It's based on a percentage, but once the commissions, or this 15% of the commissions is turned into shares, the essence changes. And the fact that it used to be commissions or derived from commissions is also irrelevant. That's another basis that the court below attempted to justify this on, and it was just simply wrong. Thank you.
Thank you, Mr. Kelly. Mr. Lax?
Yes, thank you very much. Please the court. Barry Lax from Lax and Neville, and I represent the respondents, Lerner Windenbaum, and the appellants, Del Russo and Sullivan. So what Credit Suisse is asking this panel is an extraordinary remedy. They're saying to you, not only did 2 arbitration panels get it wrong, but 2 Supreme Court judges got it wrong as well. 2 Supreme Court judges, 2 arbitration panels that heard the same case, because
Counsel,
it's all.
This is Judge Scarpullo. Do you have a single case in New York that would support the notion that this is wages?
Sure. Ryan v. Kellogg.
No, Ryan v. Kellogg was another Scarpullo case. Definitely not Ryan. Anything other than Ryan.
No, Your Honor.
I mean, Ryan was at the date.
Right.
100%. Not based on anything that happened.
Wait, when the judge is talking, I suggest you let her or him finish, then you
I'm
talk.
sorry.
All right, so let's put aside Ryan, because no, not Ryan. Anything else?
Yes, the Goldman Sachs case that Mr. Kelly was just referring to. That was unvested deferred compensation. What Goldman Sachs has a plan, and the plan states that you don't get this compensation if you're not there at the time of vesting. What both of these arbitration panels determined is that my clients were terminated without cause, all 4 of them. They also determined at that time that their compensation vested. It's vesting that triggers a violation of labor law.
I don't think that that's what True Love says. I think True Love says what determines it is whether it's dependent on something outside of the work that your client does. And that's the issue here. That True Love specifically says if the number is based on the performance of the company, that is not wages under the labor law. That's basically the True Love holding.
So, if I may, Your Honor.
With that?
Well, I don't necessarily agree with that, Your Honor, because in our fact pattern, what we proved in both arbitrations, and we showed both judges below, is that the whole case, both arbitrations, were about whether these were commissions. How did these advisors earn what was deferred? And they earned it through a commission, and we proved that. And that fact-based analysis or determination is really not reviewable on a motion to vacate an arbitration award for manifest disregard of the law. It was determined that it was a commission. A commission is a wage, and the wage was not paid because the clients were terminated without cause. So I'll give you an example. $300,000, assume $300,000 is deferred. It's withheld from my clients. It's their commissions. Then at the end of the year, those commissions are used to purchase phantom stock. At that point in time, it's fixed. So say the stock price is at $30 a share. It's 10,000 shares. So it's a fixed amount. That's it. Whether the stock price decreases or increases has nothing to do with how I got my deferred compensation, how I got my commission. It was all based upon my individual productivity. That $300,000 was dependent on my commissions on my sale of securities.
Counsel, you don't get $300,000. You get phantom stock that could be worth zero, right? You're never getting $300,000.
No,
you get a phantom stock. And if you're there on the date and the stock is worth zero, you get zero, right? So the amount that you are seeking is dependent on how the company does. I don't know how you can get around that.
Because the way we get around that, Your Honor, is when we get the 10,000 shares, that's what I'm entitled to. And if there's a vesting condition that happens, I get the 10,000 shares, whatever that value is at the time. So, Your Honor, also besides stock, there's also cash. There's also cash that's deferred. So Credit Suisse is arguing that the cash portion then would be considered a wage, but the stock portion wouldn't. That doesn't make any sense at all. Just because you call something a stock award, just because you use the deferred amount, the commissions to purchase phantom stock, that doesn't take it out of the protection of the labor law. Just because you say it so. They said that these were not commissions. They said they were credits. That's what they said, but that was irrelevant to both arbitration panels. So then every company is going to just say, we're going to defer this and we're going to buy stock or phantom stock to get out of the protections, even though this was a commission. And both judges, both arbitration panels determined that these were commissions, that they were terminated without cause, that they were unlawfully withheld, and they weren't paid. The fact that it became stock or a stock award is irrelevant. And that's True Love talks about. It's unvested deferred compensation. That's exactly what the holding is. It's exactly what the holding is in Geary. It's unvested deferred compensation. This is vested. It was our proprietary right at the time of our termination. It's their language in their contract that says, if you're terminated without cause, your compensation immediately vests.
Okay, anything else or?
If I may, number one.
Mr. Kelly, you have 2 minutes. Go ahead.
Yeah, number one, Mr. Lax misrepresents the facts. The issue is the shares the employees don't get the shares when they vest. They get the shares a year later or 2 years or 3 years later. And if you want to read the contract is in the certificate that's given out. It's at page 528 of the record. That's the contract. So they don't get anything. They get a right to receive the shares at some later date. Number two, the panel didn't find anything about whether these are commissions or not, because the panel didn't write an opinion. I don't blame them for writing an opinion, because they could not have justified the decision they came with, saying that this is somehow under the wages of the labor law. And number three, the fact is that, yeah, they get shares determined on a percentage, 15% in the case of these individuals. And that's how the number of shares that they're offered and they're going to get over time. But they still get the same number of shares, the same 15%, the same 2,000 shares, whatever it may be. But when they get it, as Judge Scarpello says, it may be worth nothing, or they could be lucky working for Apple, and it could be an immense windfall. So the fact is that they don't get anything other than a right to receive the shares over a period of time, whether they're terminated without cause or whether they stay on board and the vesting takes place over time. I think that the award of liquidated damages and attorney's fees in this case should be stricken, and the award for $2.5 million, whatever it was, of compensatory damages, that stands. We're not appealing that. Thank you.
Okay. So now, Mr. Lax, you are you speaking first on the other case?
Sure, I'll speak on that case. Thank you very much.
And then Mr. Pegno will hear from you. Okay.
Thank you very much, Your Honors. Again, when is it appropriate to render award in manifest disregard of the law? What we believe it's appropriate in a very small, limited circumstance where there is a statutory requirement and that statutory requirement was ignored. So just like the case that we showed the panel, DiGaetano versus Smith-Barney, in that case, Title VII case. It was successful, and that arbitrator saw that the law granted attorney's fees to the prevailing party, and that arbitrator saw it, disregarded it completely. So that arbitration award was overturned. It's exactly what we have here. We know that this arbitration panel saw that the 9% interest was required because they put it on the face of the award. We know that they saw that New York labor law applied section 198(1)A because they put it on the face of the award. So the fact that they saw it,
Council, but do FINRA rules trump though? Because FINRA rules don't require a 9% interest rate.
Well, FINRA requires, I mean, it's really, FINRA requires arbitration panels to follow the law and not act in manifest disregard of the law. So FINRA is silent as to the interest that's to be applied. You're supposed to apply the interest, the statutory rate.
Is there a case on that?
Right. So if you were in federal court, your interest would be the Treasury rate, right? So it could be 4%, could be less than 4%. There's no, if FINRA follows the federal rules, the federal arbitration rules. So the fact that they went one way and not 9% is not a manifest disregard, because they could have applied the federal interest rate and not the New York State interest rate, which would be perfectly reasonable, right?
I don't believe so, Your Honor, with all due respect, because I believe that the New York labor law specifies that it should be prejudgment interest. And then under the CPLR, it's 9%. And that's
okay, but let's assume that we're talking about the breach of contract claim. That could easily be a 4% interest, right?
Correct, Your Honor, but they didn't award under the breach of contract. They awarded under the New York labor law. That's what they said. They awarded attorney's fees under the New York labor law. And
okay. Let's talk about the interest. I'm focusing, I'm sorry, I was unclear. I'm just focusing on the 4% interest rate.
Understood.
So that you're not, I mean, if they went by the federal interest rate, which they're entitled to under FINRA, there wouldn't be a problem. If it's the breach of contract claim and it's the 4%, let me say that.
So if it's a breach of contract claim and if it's 4%, would they be entitled to put in any, I mean, if it's just a breach of contract claim, they could put in whatever interest they want, but we're not in federal court. We don't have jurisdiction to bring this motion to vacate in federal court. It has to be in New York State court.
I get it. I'm just saying that if we assume that those two things are true, then the 4% is okay.
If you assume those two things are true, but you know, again.
I know you don't. I got it.
Thank you very much, Your Honor. Thank you very much, Your Honor. But
yeah, we have been listening.
but there is a distinction between, and I think a significant distinction between our motion to modify this award and Credit Suisse's motion to throw out the labor law based upon True Love and Geary. It's just a total different animal. And I can't stress enough the fact that we tried these cases. All of these arguments were brought up before the arbitration panel, and the panel determined that these were commissions and they were just structured a different way.
That's what I'm asking you. Counsel said there's no decision. How do you know? How can you say that?
Because liquidated damages were awarded.
No,
so the only way that would
I thought there was like a decision that says this is commissions under the
decision is that
it's your inference from the fact that you got money is what you're saying.
It's not just money, Your Honor, it's liquidated damages. So liquidated damages are
so it could be wages and not commission.
Well, but the only way it could be awarded, really the only way it could be awarded is if they're commissions and if they're wages. So we clearly met that burden that they're wages. We clearly met that burden that they're commissions, or there's some form of compensation that's protected by the labor law. There's some form of protection affected by that. And that's the case that we've won in those two arbitration decisions, totally separate panels, different panels, same evidence. And that's the same thing that we argued to the courts below.
Okay. May I hear from Mr. Pegno, please? Thank you, Mr. Lax.
Thank you.
Whoops, you're muted, Mr. Pegno. After all that, you don't want to.
I did what everybody else was doing. I said, oh, these people, they don't know any better. Let me clarify something to start. The question that we're talking about now is not the labor law question. It assumes that the labor law applies, and whether, under those circumstances, whether it was manifest disregard to award interest at a 4% rate versus a 9% rate. So we of course contest that. And to make something clear, Mr. Lax was talking about the fact that two different panels awarded liquidated damages. There was no award of liquidated damages in the Sullivan Della Russo case. There was, just to clarify, I'm not saying that Mr. Lax is, but just to make clear, because it does get kind of confusing.
Right.
There were no liquidated damages, and he does not contest that fact that it was appropriate for the panel not to have awarded liquidated damages. And I will just make one point, because the panel has sat through a very long argument. We make a number of different arguments why it is that it's not a manifest disregard. It's in our brief. You can read it. Justice Moulton brought up the point about what the FINRA says on this point. Mr. Lax says they have to follow the law. It's a little more precise than that. The FINRA arbitrator guide expressly states that, quote, when awarding interest, a panel should apply a reasonable rate that is based on the facts of the case. And under the applicable law, that means when you have a FINRA forum, an arbitration forum has a rule like that gives discretion over an issue like interest, then courts cannot interfere with that exercise. And with that, I'll answer any questions that the panel has, and or cede the rest of my time.
Does anyone have any questions for Mr. Pegno? I think we've gone over it. I think we get your point, and thank you. Mr. Lax, you got a minute or two to end the afternoon.
Thank you very much. I would just point out that that's exactly my point. One panel ruled that Credit Suisse did not act in good faith when it terminated the advisors without cause. Another panel presumably ruled that they did act in good faith, and they met that burden, which is why they applied legal fees pursuant to 198(1)A.
So what? So is one right and one wrong?
No, they're both right, because they're both factual determinations. We're not in any way contesting that one got it right and one got it wrong. What we're saying is it's the process. The process is what's required. And the process is Credit Suisse can't get a second bite at the apple. They can't get a do-over. They can't say in some way that, hey, we get to not only go to the courts, but we get to go to the appellate courts to change factual-based determinations on what this compensation was.
All right. Does anyone have any further questions? Okay, I think we got your points. Thank you for your briefs and for the arguments, and we appreciate it. And have a nice afternoon. And I guess since we have no court officer here, I have to say the Appellate Division First Department, all our arguments for today are finally concluded and court is adjourned. Thank you for being with us all day.
Thank you very much.
Thank you, Your Honor. Appreciate it.
Bye.